Good morning. Welcome everyone to the October 3rd special land use meeting, continuation from September 29th, 2017. Is Pastor Paul McLaughlin in the audience?
I don't see him.
I did not see him.
Moment of silence for Las Vegas.
Does she know what she's saying? Sometimes they sit out there for some reason.
Okay. You don't see him, Diane? No. Well, maybe a miscommunication, but Commissioner Smith, if you would say a few words, and of course, we're going to keep everyone in Las Vegas in our memories as we pray today.
Father God, we come before you this morning, asking for you to open our minds and our thoughts, Father. Father God, all the ones that lost their life in Las Vegas, Father, touch their family this morning in a special way. Father, let them know that we're not there, but we're there in spirit, Father God. Father God, allow us to come together this morning here, Father, in your will, Father, and do what needs to be done this morning, Father. Build a hand around this chamber this morning. Allow peace and equality to come through, Father. In Jesus' name, amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'll turn up County Attorney. Do you have some introductory comments you'd like to make this morning?
Normally, staff introduces the item, and do we have citizen comments for this agenda? It's on the agenda. Citizen comments starts first.
Oh, okay. Well, this is citizen comments on future agenda items, not what's on the agenda today, but if there's something you would like to ask the board to consider on a future agenda, this would be your opportunity.
Good morning.
Good morning. Please state your name for the record.
My name is Mary DeLarco. I'm a kindergarten teacher. I've raised 3 children. I've never done this before, but I have one question to ask today. When will the property at the corner of Lockwood Ridge Road and Whitfield be cleared of the trees that were cut down last February? This is what it looks like.
Sure.
We have been living with this eyesore for 8 months. Here's another. Our subdivision, Carlisle, at Palmer, backs up to this. This is one of the only 2 entrances to our subdivision. We have the main one off of University, and we have this one at the corner of Lockwood Ridge and Whitfield. When you drive in here, it looks like you're driving into a dump. And I'm surprised more people haven't dropped off refrigerators, mattresses, and any other trash. I have seen a couple of cows. My husband and I live in Carlisle in the villages of Palmer. This is right on the corner. There are thousands of residents that live in Palmer and the surrounding subdivisions. These are just some of them. Cascades, Woodbridge, Woodbrook, Amalfi, Mandalay, Barrington Ridge, Silver Lakes, Arbor. I have to see this every day. There are piles and piles and piles of this. Now, there is a little grass in between. There's about 8 cows that get there once in a while. And you should have seen those cows during the storms. They were past their, I don't know, if cows have knees, if you call them knees, they were halfway underwater. I feel as if no respect is shown for the environment, for the thousands of people who live nearby. This is a reflection on the builder, the owner of this property, and his disregard and disrespect to the environment and to the community. I've written many letters to Mr. Bevroof, the Manatee County Commissioners, WFLA-TV, and the Herald Tribune, 3 of which have been published. I feel as if he has not shown himself, Mr. Bevroof, to be a responsible builder, And I think he should prove this before he is allowed to build elsewhere. And I know there is a big project planned. If he begins Aqua by the Bay,
I'm sorry.
Can't talk about
You can, this
I'm
is a
sorry.
quasi-judicial public hearing.
All right.
If everyone's intent is to get up and talk about the developer of today's project, that will be very, and I'm going to ask our attorney to opine on that, very prejudicial, I believe, to this proceeding. So I'm going to ask our attorney to please weigh in. And I also have an announcement.
this is my first time. I'm sorry.
Thank you.
You can strike all that. I'm sorry. All I want is an answer to my one question. When will that mess be cleared up? And would any of you like to live next to that? So I'm sorry I went off protocol. I don't know how this works, but I just would like an answer to that question. This has been 8 months.
Thank you.
Thank you.
Thank you. I do want to also announce that under our procedures, because I see all these folks lined up, under our procedures for future agenda items, we have 1/2 hour, and that is it. And so I want to make sure the clerk is keeping track of that time.
In the beginning and then at the end.
And then at the end, you can speak also for a 1/2 hour under future agenda items. But, Ms. Shank, would you please make sure, I'm very concerned, my concern on behalf of the county is to make sure that we operate today's public hearing regarding Longbar Point in the most proper way possible to avoid any kind of challenge. I think everyone in the county would appreciate that, us trying to do it in accordance with the rules so that we don't have a lawsuit. So I'm very concerned about, folks who want to speak because they're concerned about an opportunity to speak and mixing those, because I don't want to have an issue. So I'm going to go to the county attorney.
Point of order. You're using a citizen's time, so to do this, so you're going to have to give him more time.
I will,
'cause you-
absolutely,
okay,
Carol.
that's what
Good
I'm
point of
asking.
order. We'll keep track of it. We will make sure that the, whatever 5 minutes that we're asking for will get taped on to the end. Ms. Shank, if you could just maybe clarify.
Well, Madam Chair, it's my understanding that the board has previously referred the matter being discussed to the county attorney's office for written legal opinion, which is in the works. I would inform the citizens that this board is not a code enforcement board, has no authority to levy liens or penalties against the alleged perpetrator of the debris piles. So you've done all you can already. And secondly, if they direct comments only to the issue and not to a pending cross-judicial matter regarding Aqua by the Bay.
Thank you. All right. We're going to go ahead and continue. Rules say we finish public comment, and then we'll go to commissioners to speak, okay?
All right.
So, hello, you have 3 minutes to address a future agenda item, something you'd like to see on a future agenda.
My name is Michael Pepper. We Manatee County residents are at risk today. Hurricanes Harvey and Irma are fresh in our minds. So much of Houston was built on filled wetland, leaving water no place to go, hence flooding. Our Florida population has grown 6.9 million since 1994 in Andrew. 75 and 95 can no longer handle the population evacuation today, forcing us to shelter in homes or in a county shelter. I request consideration for future agenda items and workshops to increase the efficacy of sheltering our residents by working continually with the Manatee School District to ensure that schools are hurricane hardened and more schools are available for sheltering. Why is the new high school in Parrish not being hardened for use as a hurricane shelter for their residents? I request that you require all future applications for developments in the county to include a mandatory shelter built with enough capacity for every person planned on moving into that new housing development and do it on site, paid for by the developer or in the county at developer cost using future impact fees. Why not resume impact fees by developers to cover hurricane costs affecting the county financially? County emergency resources must ensure that the shelters are adequately staffed. Generators need to be tested regularly, supplied with fuel, and tested at least 24 hours before every storm. I close with a question. Have any one of you been in a shelter in Manatee County?
Thank you. Please state your name for the record. No clapping, please. This is a quasi-judicial.
I'm Mary Lynn Parker. I'm asking for future workshops and agenda items to clarify, define, and specify standards for applying the term overriding public benefit, as specified for wetlands protection in both the Comp Plan and the Land Development Code. A term overriding public benefit is one of two gatekeeper terms for wetland protection in both the Comp Plan, Conservation Element, and the Land Development Code. But unlike a very similar term in the coastal element of the Comp Plan, which is overriding public interest, the term overriding public benefit is not defined. In regard to the wetlands in the code, it is the applicant's responsibility to show how the wetland impact provides direct public benefit in excess of the detriment suffered by the public. However, when applying the term overriding public interest to aspects of the coastal element in the Comp Plan, the definition provides guidance, and overriding public interest is determined by the Board of County Commissioners, not the applicant. By having an undefined term of overriding public benefit left to the interpretation of the applicant, the term becomes meaningless as a protection of the wetlands. In effect, Manatee County's Land Development Code for Wetland Protection is a code for wetlands destruction. I beseech you to workshop and place on your agenda to clarify, define, and specify standards for applying the term overriding public benefit.
Thank you.
Barbara Angelucci, Manatee County. I've talked to you guys before about special and specific approvals. And so now what I want to do is to ask for a future agenda item that you would consider your practice of allowing them, knowing that you're not required to grant them. Traffic continues to be a problem, and it appears that most of the already permitted development is based on these approvals, which continue to exacerbate the problem. Smart growth is the answer, and the Comprehensive Plan and Land Development Code are written to ensure that and should not be weakened by special and specific approvals. So I hope you would consider discussing that. Thank you very much.
Thank you.
My name is Ed Goff, and this is an item for future consideration, a future agenda item, and deals with vertical rezoning. Imagine you wake up in the middle of the night and your house is filling with water. Now, imagine that it could have been prevented. Vertical rezoning occurs when low-lying land is covered with fill dirt to raise its elevation to a less hazardous flood level. For example, a coastal parcel of land may have an elevation of 7 feet above sea level. By adding 6 feet of fill to that property would be brought up to 13 feet above sea level, thus putting it in a lower risk flood zone, which increases the value of the property and decreases the flood insurance. There is an unintended result of vertical rezoning. Undeveloped land will absorb rain at a higher rate than developed land because developed land has less permeability area and water soaks in slower. When land has been elevated, heavy rains run off to non-elevated surrounding land instead of soaking in. Under certain circumstances, this will cause flooding of surrounding land that has never flooded before. That is the case with the inland subdivision, Center Lake, that was flooded in August after a heavy thunderstorm. These pictures here, the top picture shows before it was flooded and after it was flooded. And it wasn't just flooded momentarily, it was flooded for days and days. Vertical rezoning should not be allowed when it may cause flooding to adjacent properties or when storm surge is diverted. Thank you very much.
Thank you.
Good morning.
No, you cannot put that up there. That is part of the quasi-judicial public meeting that we're having. We cannot mix the two. You have to hold comments for that.
Well, it's another development.
Oh, I'm sorry. I
Yeah.
thought it
it's
was.
Legends Bay.
Excuse me. Your time hasn't started. Pardon me.
Okay,
Start.
I'll start all over.
Sorry.
Good morning. My name is Arlene Dukanauskas. For future land development use along the bay, I suggest that the commission attain a greater recognition of the role of the natural barriers for reducing storm hazard, exposure, and vulnerability. Photo 1 is an example of a community that retained their mangrove trees. I took this photo of the mangroves at Legends Bay Community on the morning after Hurricane Irma. This area is on Sarasota Bay, coincidentally adjacent to Long Bar Point. The deep layer of mangrove trees shown here reduces the intensity of the wind and the impact of the waves of a storm, thus protecting our homes. According to the Nature Conservancy, mangrove trees reduce the height of wind and swell waves by 13 to 66% within the first 100 meters of mangroves. Hard structured barriers, such as concrete dikes or walls, only protect against wave impacts in the short term and may need frequent rebuilding. In contrast, photo 2 shows a community that depended on a seawall during Hurricane Irma. Future planning of Manatee County land use should establish procedures to protect and enhance natural barriers, such as mangroves that reduce the effect of future storms as well as adapt to climate change.
Ma'am, anything that you submitted needs to be submitted to the record. Thank you.
My name is Karen Willey. With the devastating hurricanes we have witnessed just in the last few weeks, I request the most rigorous adherence to Manatee County's comprehensive plan and land development code in regard to wetland protection. Again and again, we have seen the devastating destruction as evidence of removing wetlands, and especially mangrove wetlands along coastal areas. Recent storms have demonstrated clearly that coastal wetlands can themselves mitigate destruction due to storm surge and wind. Delegation of the mangrove program has been, from state to county level, is authorized under Section 403.932 of the Florida statutes. Sarasota County has been delegated the authority to implement their mangrove protection program. In fact, my neighbor in downtown Bradenton, Alyssa Vinson, is the mangrove coordinator in Sarasota County, and she enforces the mangrove laws there. I request that Manatee County apply for this delegation of local mangrove protection under that Florida statute. Thank you.
Thank you.
Morning, Commissioners. My name's Joe McClash. I'd like to request a future agenda item to ensure the implementation of the county's comprehensive plan, which has goals, objectives, and policies, which you should read for yourself, for the protection of upland habitat and the requirements included in the Land Development Code for the identification at the time of approval and protection and enhancement with any approval. There's also specific conditions that apply to coastal planning areas and those areas in the coastal high hazard areas. Commissioner Benak, I think you're pretty familiar with these. So the coastal elements require you to look at the emergent vegetation, which sea level rise, think of that, and upland habitat protection. It requires developments within the coastal planning area to preserve those representative tracts of native upland communities. You have to ask yourself, have you been doing that? And require the preservation of native upland habitat during land development activities through the following strategies. Maintenance of areas of non-exotic vegetation, viable portions thereof a project site. So required to protect these native upland habitats, which is defined in your comprehensive plan as a biological community that is found in similar physical environments. And some of that is your uplands such as your scrubs, your mixed hardwoods, your temperate hardwoods, upland forest. So it prohibits the alteration of coastal wetlands. That's your policy 4.1.2. Unless there's cases of overriding public interest, and don't confuse that with the overriding public benefit. That's not defined. Overriding public interest is. So you can't mess around with these coastal wetland habitats unless the actions are required by local, state, federal government necessary for the promotion of the public safety, health, and general welfare. So you're supposed to encourage the restoration of these areas if they're disturbed or degraded, not remove them, and support the conversion of nuisance exotic vegetations and or hard surfaces along the shoreline. So you have specific habitat delineation that's required, which means that you're supposed to have it on your plan before you approve it. You're supposed to show it. Hammocks, pine prairies, scrubs. Ask yourself, has this been a practice lately? It used to be, but haven't seen it in a while. So the wetland buffers also may have larger buffers because they want to protect those areas to preserve the natural upland habitat and also the view sheds. And it's important. When I was a commissioner, I really focused on the environmental corridors because it's not all about wetlands. It's about the uplands and the transition back and forth of habitat. You also have very specific requirements in coastal hazard areas for preserving that, even to the extent that 50% of the required minimum open space, exclusive areas used for surface water retention, detention, shall be retained in natural vegetation of native upland communities, including understory vegetation. If the native upland community areas are less than 50%, then all the vegetation shall be retained. So how do you do that unless there's a calculation that's in front of you that says this is being followed? Unfortunately, you can't count on your staff to do that. You have to do your own homework like I used to. Read these comprehensive plans and codes and apply it.
Thank you. Come forward, state your name for the record, and you'll have 3 minutes.
Joe Mullery. I don't know if I have to swear in or not.
No, not for this.
No swearing, okay.
No swearing.
Please, no
Please.
swearing.
All right, I got some pictures I want to show you. This is Hurricane
Irma.
Irma. Thank you, thank you, thank you. When it hit Cuba, the sea rise was 19 feet. Surge was 19 feet. And that's one. I'll move over to the next one. I must be hitting the wrong. How do I do this again, sweetheart?
Somebody help them.
Okay, here's another one. Just imagine if this was to hit us, which it was not a 1 in a million chance, not a 1 in 10,000 chance, not a 1 in 100. All this storm had to do is go about 50, 70 hurricane miles north and right through the Keys and hit that Gulf Stream, and it would have swung out. And if things were going to be like they said, it would have swung east. Okay? Next one, please. Where do I hit? Okay. So another one. Just, there's another one. And this is Hurricane Andrew. I was there the next morning, 10 o'clock in the morning. You weren't going to die in this house. All right? Rebar iron, tongue and groove roof. I won't go into it all because it takes forever. That was the second most costly hurricane to this day. It went over rural land, farmlands. Katrina is the only one, this is adjusted money, that costs more. Okay? Next one, please. All right, okay. This is a wood house. If you're in a wood house and you got winds 145, gusting to 160, this is what you're going to get. Aluminum straps, nah. You know, if a 2x4 comes flying in there, and I've seen it go through telephone poles, and slices in there like a missile. That's it. You got the air coming in there, and then it's just going to breach, and the roof's coming off. Next one, please. All right, this gives you an indication of what exactly would happen. This at high tide, we'll go with the 19 feet. That'd be the yellow. The black is the lines showing the shorelines. So the green, the yellow, forget about it, ain't there no more. Down here in Manatee, Braden River, all the way up there, not here. Let's drop down, hey, 12 feet. Okay? That means the light blue, the dark blue, forget about it. As such, this has not been taken into consideration by you guys. It has been put forth. Climate change, hurricanes, you name it, and you have not discussed it, you have ignored it. Never, never have I seen it put forth and you guys addressed it.
Thank you, sir. For future agenda, thank you. We're going to have 2 more speakers, and then our time is up. I'm giving an extra
Half hour.
because there's been 10 speakers, 3 minutes apiece. I'm going to give 1 more because some people didn't take all their 3 minutes, but that's it. So Jane, and then after that, we've taken our half hour, which is in our procedures, for public comment on future agenda items. In the adopted resolution, that's what we're going to do, follow our resolution. Thank you.
Good morning. My name is Jane Von Haman, and I respectfully request of this board that we place a future agenda item and workshops on in light of Hurricane Irma and Harvey. There's a need to re-examine some of the transportation and evacuation routes, and you probably need to do this in partnership with Tampa Bay Regional Planning Council, because I know it's as much a full state issue or regional issue as it is a local issue. We need to look more closely at, as we develop, how we're going to accommodate those many people who need to evacuate due to storms like Irma and Harvey. We were blessed. We all know we were blessed, but we didn't know that 5 days before that storm hit. And people were traveling double and triple times just to evacuate their homes and get to safe, what they consider to be safe ground. So we need to educate our citizens a little more. I think also about hurricane evacuation in place when you're dealing with wind versus rising water. I had to deal with both, so I definitely evacuated. But that is my request. I respectfully request that we do a workshop or at looking at transportation and evacuation and resource issues. Gas was another one that became a huge issue as people were trying to evacuate. Thank you.
Thank you. Yeah, what do you do?
Joe did a wonderful job of showing you the effects of recent hurricanes. We know that besides Cuba, there was tremendous flooding.
Please state your name for
And
the record.
I'm Sandra Rittberger, thank you. In Jacksonville and Houston, and many articles pointed out that the overdevelopment contributed to that flooding and made it much more hazardous. I also request that future agenda items and workshops address the need to strictly adhere to the comprehensive plan and the land development code in regard to zoning, building, and rebuilding. The plan requires that you limit development within the coastal planning area and direct population and development to areas outside the coastal planning area. Many other communities in Florida and throughout the country are planning for rising seas and moving development away from the coast. We would like to see Manatee County do some serious planning in the future for this. Thank you.
Thank you. That completes the 30 minutes that we have.
At the end of the meeting, you can.
At the end of the meeting, you'll have an opportunity to address future agenda items. Sir, we're going to have to cut off the future agenda.
I'm say Billy, I'm here to
let
let you
him
know
speak
that
if
what
we're done.
the
Sorry.
future generation is to respect, because not only in this county, but the whole through the United States has to respect indigenous people or the God's creation, because we asked the Creator the other day after this disturbance of our ancestors. They said the nature will help us, will protect us. And they gave us the sign, and you received it not too long ago. It's going to continue if you do not respect us. You're trying to abuse us for many years, the thousands of years, or 500 years, especially Cubans and 'cause all of those people came, it's a lot of our people. It's continuously abusing our people. So you need to have to respect of our people and our ground and our burial ground or wetlands. If you plant your house in the wetland, you thought you could rebuild it, but always water's home forever. That's the way that God created it. You're going to have problems. You can't challenge God. You have to respect Him. You have to love Him. To live in that way, His way of life, in His creation. You're abusing those creation. You're abusing your future generation. Your kids going to be struggle. You're already seeing the people struggle throughout the United States and Cuba and Puerto Rico and the other country. That's how much you affect them. You challenge God. You're not God. You need to lower yourself down. You need to respect as a human being to take care of your future generation. The food, the land, the wetlands, they need to respect it. This expert, they're not expert. We create, we're above, we connected with above with them. We understand Him. They represent us, and they represent all of you. And you unbehave. You need to learn how to behave as a human being. Thank you.
Thank you. That completes our 30-minute time limit for public comment in the beginning of the meeting. It will be continued at the end of the meeting pursuant to 5.3(1) of our adopted resolution, so we're not going to take any more public comment at this time. So please, everyone, take a seat. No, take a seat. We're not going, no, ma'am. No, ma'am, we're following.
18 years of my life.
Please, Ms. Parola, please sit.
At the inland property.
Thank you, Ms. Parola, please sit.
What you say, Betsy.
Thank you. Please take a
Give
seat.
me a break. I work for you and everybody in this room.
I'm sorry, ma'am, you'll have to we're going to take a seat or you're going to have to leave. Thank you.
You don't thank nobody.
Please take a seat.
You ran meetings before.
All right, we're going to take a 3-minute break, and then we're going to reconvene. If we cannot hold a public meeting, we're going to clear the chambers. If you cannot
You can talk at the end.
go in accordance with the procedures, we're on recess. For the balance of this public hearing, I'm going to read the rules that are in our procedures, and we're hopeful that everyone will follow these rules. If not, we will ask the sheriff to escort you out. The rules are, all persons in attendance at a board meeting, hearing, or workshop shall conduct themselves in a civil manner and refrain from action that disrupts the meeting or hinders the board in performing its duties. To these ends, such persons are prohibited from committing acts of violence toward any person, making threats of violence or speaking fighting words that are likely to provoke violence, disrupting the proceedings with excessive commotion or excessively loud shouting or other noise or use of obscene or crude language, interfering with the rights of others to speak, hear, see, or attend the proceedings, being unduly repetitious or presenting matters not relevant to the agenda item under consideration, making personal attacks or insults against any person, speaking on a subject about which the board has already taken a position or about which the board has voted not to receive further comment, continuing to speak after the allotted time has expired or after having been ruled out of order, or speaking on a subject that's clearly outside the purview of Section 2.1. Those are adopted by resolution in a public hearing, and I, as your chair, will enforce them. And they also go for my board members. So we're going to try to conduct this meeting in accordance with the procedures as they've been adopted. So at this time, I think it's time to open the public hearing matter. if I could turn it over to Ms. Schenk to address the board on where we are.
There's no
I-
consent.
I'm sorry, I just read the rules. If you cannot go by the rules, you will leave. Thank you. Ms. Schenk, would you
Okay.
please read where we're at?
For clarification, this is a special meeting of the Board of County Commissioners. There is no consent agenda or advisory board appointments. They're just listed on this form because the computer punches them on automatically.
I'm sorry, you'll have to leave. Thank you.
Okay, this public hearing, get my stuff right here. Okay, I'll be Nicole Knapp and just read the project name. The project name is zoning ordinance PDR PDMU 1510 ZG Lombard Point LLP and Cargo Partners Roman numeral 8 Lombard Point LLP, rezone Aqua by the Bay. And this public hearing was continued from August 23rd, 2017 to September 29th, 2017, and which, due to lack of a full board, the applicant requests a continuance to a future date, and the future date was continued to a special meeting of October 3rd, 2017. The public notice was advertised for this meeting, and the notice is stated the public comment had been closed on August 23rd. I wanted to note in that regard that in the event the applicant submits substantial modifications to the stipulations of the general development plan at this board meeting, it can trigger re-advertising the public hearing, reopening public comment. Thusly, the board is advised to avoid reopening public comment, that any questions to the applicant or staff be directed specifically to the revised stipulations, which Ms. Knapp will review and the applicant will address. I want to give by example any proposal to include removing the estuary enhancement area or wall from general development plan cannot be covered with the stipulations. This would be a substantial change requiring a revised general development plan. A substantial modification to the general development plan would require a public comment portion of the public hearing be reopened. As previously stated, the public hearings, the board should focus on whether the applicant has met their initial burden of demonstrating by competent substantial evidence the project as a unified project is consistent with the comprehensive plan and land development code. Section 402.3.8 Land Development Code defines plan development zoning as land to be planned as a whole. Thus, we cannot vote on piecemeal portions of the project. The legal standard for review is that the approval of the project will be judged in third-party challenges under a strict scrutiny standard. This term means strict compliance with the comprehensive plan. And now I'll turn this over to Nicole Knapp, Plan Division Manager, to address the specific revisions proposed at today's meeting.
Should the clerk swear the staff in and the applicant at least?
Do you swear or affirm that the factual statements and factual representations which you're about to present to this board will be truthful and accurate?
Thank you.
Good morning, Commissioners. For the record, Nicole Knapp, Building Development Services, Planning Section Manager, and I have been sworn. The only change that we had to the agenda this morning was the packet of public comments that we received after the agenda was posted online, and I provided them to you a few minutes ago. And as Ms. Schenk already described, this is a continuation of a previous public hearing. And at the end of the public hearing on August 23rd, the applicant asked for continuance in order to have some time to address some of the commissioners' comments. On September 15th, the applicant provided a letter which confirmed their commitment to stipulations that we actually discussed during the August 23rd hearing. Those stipulations surrounded a maximum height of 95 feet, the prohibition of motorized boats, that the buildings over 35 feet were to be located so as not to create a wall effect, and that they would bring forth the project at specific benchmarks of the development, meaning after so many units, they would come back before you with a preliminary site plan. That was all captured in the September 15th letter. Shortly thereafter, Assistant County Attorney Sarah Schenk and myself opined in with legal advice or some suggestions from staff on perhaps some alternate wording that should be considered as part of the stipulations, and therefore the applicant submitted a letter on September 22nd. We didn't receive it on the 22nd, but it's dated on the 22nd in your packet, with an addendum to the previous letter. You almost have to use the two of them together. One doesn't supersede the other. This one withdrew the stipulation regarding motorized boats and the prohibition against it, and there's a legal opinion from council, offered a stipulation regarding hurricane evacuation plan, and for the record, the applicant actually agreed to this or offered this up in the very first review, and it was an oversight on staff's part that it didn't get into the staff report. They offered revised language to the stipulation regarding bringing forth the plan to you at different benchmarks, and what they did with that is they offered up 4 phases and said that those phases would supersede the phases on the plan. And then they offered a new stipulation regarding the option to remove the estuary enhancement from the plan, or should they wish to proceed with design and build, bring it back before you at PSP level. So what's happened after that is staff has not changed their original recommendation. You'll notice in your staff report that our recommendation of approval has not changed. We found the plan before you, the GDP that you all have before you, to be consistent with the comp plan and the LDC. However, we can't support the last 2 stipulations the way they're specifically written. The phasing one, for example, contradicts the phases on the plan. So if the applicant was to revise that stipulation in a way that, and this is the suggestion we provided, that if they want to bring the development back to you at, say, every 750 dwelling units, but don't call them phases, just trigger points of 750 units, then it doesn't contradict the plan. The last stipulation, though, regarding the estuary enhancement and the option to remove does. We can't have a conflicting document such as the GDP that doesn't match the approved ordinance. So that's the only additional information I have from staff's point of view. The applicant may have more to say on that. The applicant handed me this morning a revised recommended motion. The only revision is, and I'm not sure if it's in front of you, I didn't see if the applicant gave it to you. The only revision is that they want to add that these, obviously that these stipulations as proposed actually be entered, so they've provided numbers associated with those. They didn't alter the rest of the recommended motion. So I'll turn it over to the applicant if they have anything further to add.
Can I ask staff a question?
Yes, Commissioner Whitmore?
Nicole, I can ask you a couple questions because I'm the one that had brought up about the motorized vehicles in the estuary. And from what I understand legally, according to state, we can't, can you explain it?
I'm either going to defer to the applicant as to why they withdrew it, or
Not
Sarah,
why they withdrew it, but the state law. And
I'm not
then-
an expert on that matter, so I'm not going to
Okay,
answer.
our
it.
attorney had written something that they didn't agree with as far as docks. Can you, Sarah, can I ask you to clarify that, just so it's clearer why possibly they didn't, and I'll ask them also. But you came up with, trying to get the intent of what we had wanted, and they didn't agree?
Well, the applicant, in a letter dated September 22nd, stated that they withdraw the proposed stipulation. They did not want to propose the alternative approach in my memo, and that's their right to do so. At the August 23rd board meeting, the applicant was asked to bring back a stipulation regarding motorized vessels not being allowed in the estuary enhancement area. The authority to exclude motorized vessels and waterways is generally reserved to the state under Section 327.461B Florida statutes. A vessel exclusion zone must be enacted as an ordinance of general applicability, not as a stipulation in zoning ordinance, and involves certain state agency review and a focus on public safety. The alternative stipulation I drafted out would have been contained in notice to buyers and would have been applicable to people who own property and had private docks, so they couldn't launch motorized vessels from those docks, because that's within control of the applicant. And they declined to accept that stipulation. So there is nothing addressing motorized boats in the proposed stipulations at this time.
And I've met with staff, as you know, 3 times since the last meeting. And regarding the estuary, the phasing, or whatever you want to call it, Phase 1 would be today. I mean, we would be approving the GDP today, correct?
The way it's presented.
Okay, and that would be Phase 1.
No, there's 7 phases on the GDP.
But what, when I had spoken to you and helped me with this, that if we approve the GDP today, the estuary isn't until Phase 2.
But it's shown on the overall GDP,
Exactly.
correct?
So if we approve the GDP, then essentially, and I'm asking the attorney because legalities I want to know, and I want it for public, if we approve the estuary today in the GDP, we've approved all the entitlements of everything that's been presented to us, correct?
Basically, the focus is you'd be finding the general development plan as a whole unified project, including the estuary enhancement area, consistent with the comprehensive plan. Now, the applicant's proposing to have subsequent public hearings on different components of the project. And the point I'm trying to make is that those subsequent public hearings, the review by the board is more narrowly focused on design details of the building heights and so forth. And Mr. Gerstenberg can comment, at preliminary site plan level, you don't get engineering details on estuary enhancement areas. So the vote on the GDP approves estuary enhancement area. It's just engineering details. There's no point in holding public hearings on those. Mr. Gerstenberg knows better than me how to comment on that component if he wants to add anything.
Because even though it says, yeah, Tom, go ahead, and then I'll.
For the record, Thomas Gerstenberger, Public Works Department, has been sworn. Madam Chair, Commissioner Whitmore, with respect to the estuary enhancement area, the general development plan and preliminary site plan level only identify and reflect intent. They do not include technical supporting data, calculations, modeling that supports the design or intent of the estuary enhancement area. That would be included with the final site plan and construction plan level of review.
Okay. When the next phases come before us, Madam Attorney, to look at for public hearing, et cetera, they're still, since we've approved the GDP, they're entitled to what was presented to us, correct? I'm thinking legally down the road. If you're entitled to something and then we're at a public hearing and we say no, that could be some kind of exposure to the county.
Well, that's potentially if you approve the stipulations the applicant's proposing, and they numbered A18, A19. Normally, we wouldn't be having subsequent public hearings on the GDP unless they made substantial modifications.
Okay, thank you.
All right. I'm going to ask, since the applicant submitted these proposed stipulations, and they conflict with the general development plan phasing, since they submitted them, tell us how you plan to rectify that problem. We can't approve it, according to our attorney, with two conflicting phasing plans. So what's the intent here?
Sure. My name is Ed Vogler. I'm the attorney for the applicant. I have been sworn. And we're, like you, trying to manage this process, and we're trying the best we can. But before we go further, I'd like to thank you all for your kind attention and your serious consideration of these matters over all of these hearings. We know that you have a lot of responsibilities in the county, and it's been a trying period. And those of us who are in the development community and deal with land development, we deal with only a portion of what your role is. And but we're very appreciative, and we're respectful, and we're grateful.
Stop.
I want to also say that we're extremely grateful for your staff, your professional staff, including the county attorney's office. These matters are complicated, and we've collaborated well. So the short answer to the question, Commissioner Benak, is we're trying to present a set of project stipulations that respond directly to the concerns expressed by members of the commission. Our objective is to say in the most transparent way that we have heard you. I'm going to deal with them specifically, but generally, we have heard the commission, the decision makers. We've also heard the public, as have you. But we've heard the decision makers express concerns about certain matters. And our objective is to present stipulations that respond directly, completely, transparently, without equivocation, without any type of evasion or sub rosa plan, just whatever words that can be crafted to implement that understanding. We are amenable to that today. Our objective is to obtain an approval from this board. Your codes set up a general development plan, large project profile. I mean, what really is at the gravamen of some of these questions is you're often presented with preliminary site plans. In DRIs and in large projects, you're presented with general development plans. And so the overriding comment is sort of, look, I'm not sure I understand that element, and I would like to see more detail or more plan or more something. And so that's our objective with these provisions. Commissioner Smith was concerned about approving a large project for an extended period of time. That's very rational and thoughtful, and we understand that. And so we've tried to say that every 750 units will come back to this board with a preliminary plan. And you heard testimony in the public hearing that said basically you're going to be impressed with the first pieces of the plan, and there's no reticence to bring back for board approval any other elements of it, and we've crafted a stipulation that says that. Not our intention to be inconsistent with anything. I would observe, Commissioner Back, I mention you because you asked the question, but all of you, I think it's been 36 years that I've been doing this type of work in this county, and we often have stipulations at the end of a project approval that is different from the plan that's approved. For example, roadway connections, sidewalks added, no access on particular streets and so forth like that. You don't make us go back and modify the plan to a set of concerns that hasn't yet received board approval or consideration. We don't know, as we sit here today, how these matters will be observed by the board. So, but let me just say this to Commissioner Whitmore. I disagree entirely, and we can fix it by words, the idea that the estuary enhancement area and wall is being approved as part of this plan. What we're saying to you is that that would require further action of the board. And I heard what Mr. Gerstenberger said, and nobody said that to me before today, so I would be prepared to say that we will bring back final site plan and construction drawings for your consideration. I think you can probably observe that there's another part of this, which is to eliminate the upland retaining wall and the estuary enhancement area and seek further approvals based upon comprehensive plan and land development code criteria. That would mean, of course, that there would be no estuary enhancement area and there would be no upland retaining wall. And these are subject matters that we have heard commissioners express concern about in deliberation. And we're reaching out to you today to say, let's work on whatever words we can work on today to say that that will happen in that way.
Okay.
Period.
All right, I want to ask clarification. So, because that's obviously my biggest concern, is the estuary enhancement area in the buffer.
Right.
Flat out. If that's a fact, I'm prepared not to vote for this because I don't think the buffer should have an estuary enhancement area. I don't think it should have a dug pond, whatever we're calling it, in the buffer. To me, that's not a buffer. So I appreciate you saying that. So what are we proposing? To withdraw it from this application at this time? Or to?
No. You know,
Substantial change.
I don't want, I'm sorry I'm being blunt, but it's, there's just, we're at that point where we're got to be very blunt.
I want to be blunt too.
It'll be a
Okay.
substantial change.
In every project I've ever worked on, we would say to you, we withdraw it. And we'd draft a stipulation and we'd say it. Boom. Right? But there are pieces of the review that say, well, you know, maybe you should redraw the plan, and there's inconsistency with the general development plan, and maybe it should go for, 6 or 8 more months of public hearings, and maybe that's the way it should be done. Now, I think that's patently ridiculous, okay? I've been here 36 years. We've done this every time. This is how we do it. We crafted this stipulation as an option so that no one could say we're inconsistent with the general development plan. But we exercised that option.
If you would add to this that it will not be located within the comprehensive plan required 50-foot buffer, I'm going to say 51 because of the way I read it, 51-foot buffer, then I would feel better about it because our comp plan specifically says you got to have a buffer. And from a coastal wetland, I think that's very important. And I don't think we should have a modification of that buffer. So that is what I am asking, for you to modify that language. And I told the county attorney, since you all introduced this stipulation, that I felt I could bring that up at this time, to say that this estuary enhancement area will not be located in the required coastal wetland buffer.
Commissioner McLeod,
What did you just do?
Oh my God, I'm sitting next to you.
Oh my God. Can we take a break? I need a break. Can I have a break?
That's
please?
not funny.
I have said stupid things in public hearings. That may jump the
my
shark
God.
right there, I'll tell you. All right, so I'm so sorry. I try to be professional.
It was a
I
mistake.
posted puppy pictures. I think that usually works.
Leland Browns.
Yes. But anyway, Commissioner Benak, I don't want to in any way equivocate on this point. We agree.
Okay.
Commissioner Whitmore, we agree, right?
Tell us.
Words, right? Is it really the commission's objective for us to take about 1/4 of an inch or 1/8 of an inch of a plan, right, and go back and revise it, and then come back here and have?
I know, I'll talk for me, because I still have the floor, and then I'll go to Commissioner Whitmore. I know for me that this has been a long process, that the public lots of times doesn't understand. So many people have asked me, as I said before, why are we back here again? You already denied it once. No, we denied a actually, I can't remember what, if it was a denial.
Plan
it didn't
amendment.
happen. Plan amendment to change it, eliminate some language in our comp plan. That did not happen. That was the action that was taken. This is a site plan and rezone request. A little bit more detailed, but it has to be compliant with the comprehensive plan. So I appreciate everybody who got up and said, you got to comply with your comp plan. Can't agree with you more. We has to comply with our comprehensive plan and our land development code. So that's the stage that we're at today, trying to get there. And it can be tricky, and lots of times we do it through stipulations. But under our new legal rules, we have to have you basically proffering these changes, and we have to make sure that it's within the discussion. We've heard from the public. I do read everything. We've heard continually from the public on this. I don't think that just keeping it going for sake of keeping it going is worthwhile. I think we want to come to some, I know many of us want to come to some conclusion
Yes, ma'am.
today if possible.
We want to, I understand this idea of us proffering. I get it, but we'll sit here right now and collaborate on words that'll have votes, for approval, I mean, somebody's got to
Take a break to
collaborate
do
with
that.
us so we know what words to select.
Let me,
I know,
I
that's
asked our
not the only
attorney
issue.
this.
We're
Yeah.
going to keep going. Thank you.
I
Commissioner
actually
Whitmore?
met 3 times to talk to our attorney about this. And as soon as yesterday I talked about it, can't we just ask the applicant? I support the development. He has every right to do that, 2894. I'm fine with that. Thank you for bringing the height down. The estuaries, it's one I can't support, but I said, can I just see if they will eliminate it? And our attorney says that that's a substantial change, and then you have to go back to public hearing because they got to redo the maps, they got to do all this stuff. And then I asked staff, well, when could we meet again? Because you know, and I respect all you guys, you know that. But I just don't support this estuary. And staff said they couldn't have it ready by the next meeting, which was the 11th or something. And that time is money. I mean, I wish we could break the rules and do the, oh, of course, we're not allowed to. Yeah, sorry, Joe. But we have to open this up for public comment again. And I said to the attorneys, I don't think anybody would make a public comment after that if we get rid of the estuary. But no one's some.
Right,
So I don't know what to do, but I don't support the estuary, and I guess now's the time to say it. Especially when I heard about the motorized vehicles. I understand it's a state law, and, you know, I'm just trying to protect
Commissioners,
my commitment.
I'm at a quandary because I am happy not to build the estuary enhancement area, period. Okay?
Take a break.
So I don't understand the conundrum because I've been before this board for 29 years. It is not uncommon for us to come before you and say, like I did at Mulholland and Fort Hamer a few months ago or a year ago, where there was a connection between that project and Chelsea Oaks that was, I built Chelsea Oaks. At that time, the staff said, you have to put in the secondary means of access. So I did. So I stubbed to it. So then I come in with my new project 12 years later, stubbed to Chelsea Oaks. I get a bunch of homeowners from Chelsea Oaks don't want this. Look, I'm just doing what I was told. If you don't want this thing, I'll take it out because I'll put another connection. So right at the dais, we took it out by words, and I built a stub road to Mulholland. Problem solved. I do not understand now why I can't just say, folks, either I'll build the estuary thing 51 feet away, which is not what I'm going to do, or I'll take it out completely without having to go through this process again. I don't understand it. I'm a common sense person. If I agree to something in writing, why do I have to go and take up all of your time again? At the end of the day, we think the two major issues was this and Commissioner Smith's comments not to lose control over the whole project, which we hopefully address to your satisfaction, Commissioner Smith. And that's it. So I don't understand, quite frankly, why we can't say we will not build the estuary enhancement lagoon, which we thought was a good idea, but apparently it's not. So
Okay.
on we go.
I saw the floor.
Oh.
I'm sorry.
Yes, ma'am.
And I know that if we could do something, some kind of legal document, that you would do that. And I think that would alleviate 99.9% of our concerns as well as the community's
That was my
concern.
hope. That was my hope.
So I would ask after we have discussion if our attorneys can talk to them to see why we can't do this. We've done it so many times. I've been
Yep,
up
it's
here
been done
a
many,
long
many,
time.
many times.
This is what I would propose and ask. So we have two issues that have been brought up. One, to at least have the estuary enhancement area moved out of the buffer
If that's, it,
or eliminated altogether. That's what you're proposing as a stipulation. Well, hold on, Carlos. And the other one is to try to come up with some stipulation to do phasing. If those are considered major changes to this general development plan requiring public comment, then why don't we do public comment on just those two issues and try to get through today and finish it? Is that make?
I just wanted to point out that the stipulations proffered right now do not eliminate the estuary enhancement area. This is the first time we've heard this from the applicant, so I'm just
but
pointing out that.
Commissioners, we were told that
Let
would
her
not be
finish, and then we'll
acceptable.
let you talk, one at a time. Sarah, are you done?
Yeah, my concern with, and to address with your comment just now, the applicant has to have entered into the record a plan that takes the estuary enhancement area off the plan.
Cross it off.
And you get a public comment on that.
Well, that was my question, mine also, because the same thing with the phasing, and I was gonna ask staff. So we have a phasing plan that's different than what he's proposing in the stipulation. We also have an estuary enhancement. I looked at the schematic. It doesn't show the edge of the mangrove wetlands. It doesn't even identify it. It shows the 50-foot buffer on the other side. So that could be a stipulation that doesn't change the plan, because the plan doesn't show that. As I said, that line at a, whatever, your 1 inch equals 1,000 feet, you can't really tell where 51 feet is. So I don't see that as a change to the GDP. It could be an added stipulation. The other one, the phasing, and I'm going to ask staff, is the phasing plan is in the GDP today. What did you rely on for that phasing plan?
750.
What did you rely on? Because phasing, for a large project usually means when a certain improvement will come in. That's why you have phasing per our code, right? So what did you rely on in the phasing plan? Could we strike it in the GDP and go with the stipulation or not? From your review perspective, and I know I'm putting you on the spot, I guess, a little.
I have one request of the chair, if I could, before we continue. The constant chitter chatter behind staff is very distracting. It's very hard to hear you,
Sorry.
and it's not your fault. And we have a court reporter who can't hear if it's not quiet.
Okay, I get it. We're talking to everyone here.
Everyone.
Please, we'll try to keep the noise down so we can have deliberation up here, which is what we're supposed to do.
I can't hear the conversations between you and the applicant. It's very distracting. From a planning standpoint, the phasing is very minimal because personally, we don't have something in the code that says you must build so many units per phase. So it's the flexibility of the construction of the overall project. From an environmental or standpoint, the two Toms may have something else that they would like to weigh in on.
Okay.
Regarding the estuary enhancement area,
Your name?
Oh, I'm sorry, Tom Pride, I have been sworn, consultant for the county. Regarding the estuary enhancement area and the applicants proffering to remove it from the plan, I guess it begs the question, the estuary enhancement area currently is the mitigation, or would be the mitigation for the proposed wetland impacts.
Right.
So if the enhancement area went away, I would be led to ask what would be offered as mitigation, or first of all, would they continue to have these wetland impacts, and if so, what would be the mitigation for those impacts? So without seeing those in a GDP, it's kind of leaves it, wide open.
Okay, thank you. Anything else on the phasing from utilities or transportation? Okay, so from what I'm hearing, is changing the phasing where it would be a change to the GDP, no doubt, because the GDP in the backup material had a different phasing plan. This phasing plan could be substituted without significant impacts to the GDP. Did I say
Well,
that?
the problem is the conflict. There's internal inconsistency. The numbers have to match.
Yeah.
There's a problem here.
No, they're saying they're gonna wipe out the phasing they had proposed, and they're proposing new phasing.
If they
That's what
submit a
they're-
revised GDP that has that corrected.
Okay, we could not do it.
No, we have to have the documents consistent with each other. We're looking at a lawsuit one way or another, approval, denial. I don't care what you do, approve or deny it. I just want to win a lawsuit. I want to win the lawsuit, okay? So I'm making the documents consistent. I don't care how a document does it, but they got to be consistent.
Let's take a break, long break.
I don't want to take a break until everyone has had a chance to talk, because as has been stated, there are other issues, and what we're trying to do today is to go through the issues, deliberate where the board is, how they're going to vote on this, or if not vote, continue, whatever is going to be happening, we need to hear from all of our board members. So Commissioner Trace, you're up next.
Yes, appreciate saying about the estuary enhancement taken out, but I also have a very big concern with the wall and the fill.
So that goes with it, the wall.
It wasn't mentioned, so.
Yeah, it's in
But I really think we're going to have to, even pull it out, we'd have to redo another plan. And did we need to do ex parte today?
Yeah, I guess we do. Thank you for bringing that up.
I wrote you a note, you just haven't seen it.
Betsy ex parte.
Just to say,
That's the note, it says Betsy ex parte.
Just to let you know, since we're ex parte now, I was in a meeting with Mr. Baroof about a week or 10 days, had nothing to do with Aqua by the Bay. We never discussed Aqua by the Bay. And of course, I've read plenty of emails.
Thank you. Anybody else who had ex parte communication? Commissioner Baugh.
Not ex parte communication, but I did have a communication
with the applicant over another piece of property, and I was going to bring this up earlier after public comment, but chose not to because it's not ex parte, because we didn't discuss this particular issue. There was a discussion on another piece of property that he owns that seems to be a big issue with some because of the cutting of trees and so forth. And in trying to settle that situation, I did have a conversation with the applicant. Anybody else? Steve, any ex parte?
First of all, yes, I got a lot of emails, and yes, I read them all. And actually went back and read all the old ones too, so I'm now fully versed on all of the pros and comments from people. And secondly, I did have a meeting with the applicant regarding another project that he's looking at that would involve Manatee County, but we did not discuss at all this project at all.
Thank you. Carol, any ex parte communication?
Just people on the street stopping me when I'm walking my dog. This morning even, so yeah, that's about it.
Robin, anything?
Just people stopping me or calling me, and I just tell them I can, and I've read all the emails and so forth, but no communication with the applicant at all.
Charles?
Same emails, people calling, and I'm letting them know I couldn't talk about it. And I need to mention this, in one of my classes, Mr. Brew name came up about this development from the instructor. I about to put that on the record. That he was on the state constitution and he was a developer, and, so. Okay.
It's not ex parte. And of course, a lot of people do ask me, what's going on with that? When is it coming back to hearing? I do answer a lot of those questions. Why is it coming back? I try to explain the difference, why we're still in it. But that's about as far as I go. I've not had any ex parte with the applicant about this that I hadn't disclosed before a long time ago when he was just trying to move us through the process. So thank you for reminding me. Commissioner DiSabatino?
Well, I'm recalling sitting here many months ago from the very beginning and saying if I could have talked to the applicant, I would have said, remove the estuary enhancement area and lower the height of the buildings, and maybe we would strike a deal. So I'm running on empty. I didn't fall asleep till 3:30 worrying about this, and then I had to get up at 6:30. So, as you said earlier, we're very cognizant of what's going on in our community, and making sure that we do the right thing for our constituents. The overriding public benefit and interest is probably of paramount importance. So I had written down you need to change the phasing, and you need to coordinate all that, eliminate the estuary enhancement area, remove the wall, and I believe also on people's minds, the height of the buildings and the the ancestral burial ground. So I think those two issues are still on people's minds.
Okay. I'm next. I just want to address the idea of coming back with a preliminary site plan for, to look at the height of the buildings under our land development code. And Commissioner McClash, you'll know this very well because you were sitting in the seat when that ordinance was written, and I was out there representing this development in its past phase in 2004. That's when the height ordinance was written. And it was written to provide design parameters to make sure that we knew we were probably going to have buildings over 35 feet in height. There is not a prohibition in Manatee County against building a building over 35 feet. So all the emails that have been sent to me saying, please don't violate your code. If we approve a building over 35 feet, it does not violate our code. It has design standards that it has to meet in order to do so. The difficulty that I see, and the reason I kind of like the idea of a new phasing plan, coming back at preliminary site plan, is you could have those details. So where we say, there's going to be buildings over 35 feet, which I think is an appropriate thing for this site. You've got tall mangroves here. Why would you want to put single-family homes? You know who trims the mangroves? all the people that live in single-family homes. People that live in higher rise, and I'm not gonna call them high rise, they're mid-rise by definition, what's being proposed, by definition, 10 to 13 story is mid-rise, if you look at ULI standards. They are, in fact, not going to trim mangroves. They don't have the right to trim mangroves. But those single-family homes, and I think most of you know, a lot of single-family residents that trim the mangroves. So what's the best way to protect the coastal mangroves, to me, is to have taller buildings that are set back behind the buffer that will have a view, as this site has, of the water. I know many of you don't agree. You think that this community only should have 35 feet height buildings. I don't agree. I think that this is the appropriate site to have taller buildings, 95-foot buildings, okay? Are there going to be a wall of buildings? It looks like it because they're asking for so many units, but they haven't designed the plan. We're at a GDP. It's a bubble plan, basically. So I like the idea of coming back with a preliminary site plan and showing what those future buildings will look like. I think we have the right to say, nope, that doesn't meet our code at a preliminary site plan. Talked with the attorney about that. Start giving me dirty looks. That I think that it, in fact, we're proving the height, yes, but it's got to be shown at the preliminary site plan that there's no wall effect and that meets the step down and meets the design standards we have. So that's the way I feel about height.
My only concern, Madam Chair, is that you're making the specific finding in this motion, whenever such time you may vote on it, that the height is compatible with surrounding area and it meets all the requirements. You take that finding out, I'm fine. We'll come back later.
Well, I think that the height meets the specific findings as shown on the GDP for the setbacks, because they've shown setbacks from adjacent properties, how far they're set back, that it's not incompatible with the surrounding area. But when it comes to and they've shown designs that will be consistent with, similar to another project that we had approval, that it showed design standards, showed different design types, that would be consistent. But I want to see exactly where the placement of these buildings will be and the design at the preliminary site plan when they can show elevations that they'll have more developed because they're actually maybe building them at that time.
Well, I'm just saying the board is constrained. I mean, as a planner, you understand that, but not everyone sitting around this table understand that. Or there might be other people sitting here 5 years from now when it comes through. Well, it could be 20 years from now. It's a 20-year project. It's a large project, and they take 20 years to build out at least. And once you find these specific findings done, you're done with it. You don't have any discretion
Maybe
later
we
on to
could
deny
add-
it.
maybe-
So I respectfully disagree with your conclusion there.
Okay.
Nowadays, you roll out the green carpet or red carpet to someone, you allow them to get the specific finding, you're done.
Right.
They rely on it, they spend millions of dollars hiring people, and they develop the site. You can't later on defeat a estoppel argument by saying, no, sorry. PSP, I like your PSP, bye.
Well, would there be any purpose in us reviewing a PSP? I don't want to, if
Well-
you're saying there's no purpose.
Well, I'm
in-
just saying that I don't want to create a false expectation by anyone sitting around this board as to what your discretion is later on. It's very narrow. It's a ministerial approval. It's very narrow. It's not the broad approval we have now, and I just wanted to state that.
Commissioner Whitmore.
Well, I think we've come a long way from the last 2 or 3 meetings. We've lowered the heights, I think it was 145 or 143, to the highest would be 95, which is the same height as Lake Flores next door on some areas. And I saw that the taller, I think there's 4, 6, 95 foot, and that was going to be in the center of the property. I read that. It's not going to be along the shoreline. Again, I don't know how to do this, but we've done it, and Carlos is right. We've done this a million times. I know the communities, people that I have spoken to and heard, don't want the estuary, and if that's going to be eliminated in the wall, great. The height came down from 145 to 95 for just 4 buildings, and the rest will be lower. I get paid, I'll sit here all day to listen to public comment to move forward with this. I don't want to come back. They don't want to come back. You don't want to come back. I think, but, shh, please. But you, it's only because this is like a court, and, you know, and trust me, everything being said is being written down. But I just think that we need to, if my intent was not to support the estuary and the tall buildings, mine have been addressed. So if there's some way that we can get this moving forward, I'm fine with it. And if we can take a few-hour break and come back at 1:30 and see if there's something that can be crafted, I'm fine with that too. I will be here all day and all night. I've marked it out.
Commissioner Johnson?
Again, I think I'll, echo Commissioner Whitmore's comments on, obviously my big concern was that pond that they were putting there, or estuary enhancement area, or whatever they called it. In the wall, obviously, like Commissioner Trace said. But I think, looking back over, what is this, our fourth trip down this road, I think, we've heard from, a lot of the residents. And I think the applicant has heard a lot and has consistently, addressed their issues. I think today's offer, pro-offering, getting rid of that whole enhancement area, is a really good show of faith. It's my district. I live out there. I've watched IMG go nuts with their growth. A board prior to me, approved the Lake Flores project with some 6,000 homes, 2 million square feet of commercial space, 1 million square feet of retail space, which to me is about the size of the UTC Mall. I've seen the Penn Bay project get approved again before I was up here. That's another 1,900 homes. So this is an area that's in transition, and this land's going to get developed. And I think if it meets all the necessary codes and setbacks, so we protect the mangroves, we protect the Cortez Kitchen as part of this, then, if we can do it and do it today, I'm all in favor of that, because I think I think we've all, have listened and are getting tired of arguing the same points over and over again.
Yeah, and I think we do need to take a break, and we're going to take a break, but I want to make sure that we know where we are before we take a break. Because I know from reading the emails, there's a lot of misinformation out there. This site is zoned for development. Is that correct, Nicole Knapp?
That is correct.
So the site is primarily zoned planned development residential, which was put there back when the zoning was created after the comprehensive plan was adopted, roughly in 1989, for the most part, I think. Is that correct?
I don't have the history in front of me. I can get that for you.
She does.
Fortunately or unfortunately, I know it. A lot of this site that is zoned PDR, what happened when Manatee County adopted their comprehensive plan in 1989, this property, because it was coastal property, was given a PDR zoning, which for the most part, there's some little parts that have to be rezoned, to recognize that it would have to go through this process before it could be developed. So many people have asked us not to approve anything. That's just not realistic. We cannot take people's property rights unless we pay them for them. We cannot say that nothing will happen on this site unless the county pays them the money that they're entitled under the comprehensive plan, which designates this site for how many units an acre, Nicole?
It's a mixture of, it's a mixture of Res 6 and Res 9.
6 and 9, yeah.
6 and 9 dwelling units an acre.
Correct.
Are they
Majority Res 9, majority,
Okay.
like 80%
Are they
probably.
proposing development that is over the comprehensive plan limits that they have?
No.
No. So again, your board doesn't approve projects because we want tax dollars. We sit here as in a quasi-judicial position, as trying to determine if they're consistent with the comprehensive plan. And if they are, we basically have to approve a plan. So I know that people say there's way too much traffic. We're going to have hurricanes. Oh, yes, I'm afraid that's probably true. We do need to look at sea level rise and how it's going to impact it, but we'll have to change our comprehensive plan to do that. They're here with an application that we have to determine today whether or not it's consistent with our comprehensive plan. We don't get to just say no. I know, probably kind of a speech. So that's where we're at today, trying to figure out if it's consistent with our comprehensive plan and our land development code, then what are we going to do? We're going to give it one shot where we can see if we can come to some agreement on the proposed stipulations. I think everyone has said what their concerns are. Are there any other concerns, Commissioner Smith?
Madam Chair, I echo mostly everything that my colleagues have stated. to get this issue settled today, one way or the other. If we have to open up public hearing, I'll support that. I mean, I personally feel I shouldn't even be dealing with this. It should have been dealt with a long time ago. So let's deal with it today. If we have to open public hearing up to get that done and have to stay here to 6, 7, 8 o'clock, that's what I want to do.
Okay. Commissioner DeSabatino?
Yeah, since several of us are mentioning the height of buildings, and you're saying the 95 feet, that's still probably concern of some of us about having any building in excess of 95 feet. Also, I still have concerns, and Mr. Gerstenberger knows that I have concerns between this community and Legends Bay, that I don't think that, and I'm not an engineer, but I don't think that the swale or ditch between the two properties is sufficient enough to take into consideration a huge storm event like the no-name storm and similar to that, because I don't want this project to overburden Legends Bay and drown them out like Center Lake was drowned out from other projects. I just don't think that the engineering of this ditch is deep enough or wide enough.
Madam Chair, Commissioner DeSabatino, the ditch in question that you are referencing to is the drainage conveyance ditch that is located between this particular project and Legends Bay. It was graded in association with the Legends Bay project. It is actually located on Legends Bay project itself. There is a drainage easement that was provided for that particular ditch on the plat associated with Legends Bay. The ditch in question is from the construction plan and from the record drawings. The cross-section of that drainage ditch is predominantly 20 feet wide bottom with side slopes that extend 20 feet in both directions. So overall, the ditch itself is 60 feet wide. There is also a drainage easement that was recorded and provided on that plat that is also 60 feet wide. The ditch itself is designed to convey runoff from the Manatee Fruit property to the north of this particular area, north of El Conquistador Parkway, in which there is a twin box culvert. I won't go into specifics, but there is a culvert crossing underneath El Conquistador Parkway itself, in which that runoff from Manatee Fruit property drains southward towards Sarasota Bay. With respect to your concern regarding the capacity or conveyance capacity of this particular drainage ditch, Legends Bay was designed to collect and convey their internal runoff into stormwater facilities that are provided with that project. That also would hold true for Legends Bay. They would be required to design and grade that particular project to drain the internal runoff.
Aqua by the bay.
Aqua.
Correct.
Right.
That is correct. I'm sorry. So both Legends Bay and this project, subsequent project development, would be required to drain and collect internal runoff into internal stormwater facilities for water quality treatment only. That water quality treatment standard for Sarasota Bay is for 150% water quality treatment, which is equivalent to 1.5 inches of runoff.
So that's water quality treatment only, not the flow.
That is the water quality treatment only, correct. There is no attenuation requirement for either Legends Bay or for this particular project, Long Bar Point. With respect to that particular drainage ditch, I would also note that this particular area on the flood insurance rate maps is located in both the velocity zone and the upland areas outside of the velocity zone are located in areas known as AE flood zone, where the base flood elevation is determined. The base flood elevation has been identified in past previous hearings is around 12 to 13 feet. I could look up specifics, but I'm just going off memory. The base flood elevation for this particular area is 12 to 13 feet. Therefore, during a storm surge event, it is likely that the storm surge itself would flow backwards, would flow back up this particular drainage ditch.
It would backflow into the drainage ditch.
Correct. Yes.
Okay, because we've just seen that in many places that we're battling down in South County, and I'm trying not to reinvent that wheel. I'm just really concerned with that engineering, because, you know, they have projects on either side. They have Tidy Island, which has the one means of access to them, which is their little bridge, and if that would flood out. But I'm glad that the estuary enhancement is now off the table, because that would be a really kind of a wall of water going in either direction. So I'm glad that's off the table, but, you know, I think we're going to have a workshop moving forward with the drainage in Center Lake area, and that would kind of coincide with what's going on all over the county, because I don't want to build new communities up high and then it overburdens the communities that are already there. Sea level rise, big events, stormwater surge. We were really, really lucky. And, you know, as the gentleman here said, you know, the gods were looking out for us. Right now, we're still battling the debris, and thank goodness it only was with 10 full days with the power, but it could have been a lot worse. And you see that powerful picture of the water. I'm just really, really concerned about, they're not building any more than they're entitled to. And I understand that, but it's still in a sensitive area where water can come right up that bay, coming up from the south or the west. So I do have, and there's, we had talked about the piece in the very top that doesn't qualify for insurance as well.
Madam Chair, Commissioners Sabatino, that is correct. The northwest portion of this project is located in what is known as the Coastal Barrier Resource Area. Hoping I got the acronym right, but it's the CBRA. That particular area is an area in which no flood insurance policies would be issued for any development within that particular area.
So what we've seen in just recent history is if they're going to get a mortgage, then they won't be able to get flood insurance, so they won't be able to get the mortgage, so they're going to have to pay cash.
Right.
But even so, I know I live in a house that's not in the flood zone, but I opt to get flood insurance because you never know. So now if these properties flood and they can't get insurance, we get the calls all the time. You know, it's my home, I invested everything in it, I can't get insurance and I have no more money, and where can I live? So those are my big concerns about this, this and other coastal projects. So, again, I don't know if the board has an appetite to talk about the height of the buildings. Yeah, or they're fine with 95 feet, but then when you do the calculations, there's a boatload of the buildings, so I don't know what the appetite of the board is to address the height of the buildings.
You did.
I don't have anyone else on the board, but I did want to ask the issue about the archaeological sites. There is a stipulation number 12 that provides protection for the archaeological sites. Is that because the archaeological sites are under the jurisdiction of the Department of Historical Resources? Is that why it's written the way it is? And I had seen something where there was nothing at all addressing it, but I read the staff report and the ordinance last night, and it does have a stipulation. So if you could explain maybe stipulation number 12, if that is adequate to provide?
That is correct, and that's a stipulation we boilerplate use, but it's also mentioned in 2 other locations of the analysis of our report. That's not the only location.
Yeah, Madam Chair, the stipulation's been in there since the beginning. The applicant just added the last sentence to clarify Chapter 872 Florida statute applies, and that's all we can require. We
Okay.
can't go to the extreme level that some groups are asking for to never move burial sites. We can't do it. The state has said you can move them. Here's the process for doing it. I don't know if it's going to be required this site. It has to be examined further. This whole process in the statute for notifying the state archaeologist if there's an issue through the course of the 20 years of this project being developed.
Okay.
It's all a state process.
Okay. All right, other questions before we take a break? We're going to take a half-hour break.
That's it?
Yeah.
To see if there can be any changes to these stipulations.
Yeah, Madam Chair, I just want to point out, I've just been perusing this GDP while I'm sitting here, and Tom Pride's correct. There's wetland calculations, stuff has to change. There needs to be a new GDP that's correct, okay? If we're walking into a lawsuit, the GDP needs to be revised to be correct, to be clear what you're voting on.
Okay.
And I just want to make it clear, if you do this by stipulation, do it against legal advice. But if you order me to do it, I'll do it, because I work for you. But I'm just telling you,
We
we're going
work
to step
with
right
them,
into
so
it.
this is our quandary, obviously. We don't work independently up here. All right, so it sounds to me like we're going to need a new GDP if we're going to, so that's what it sounds like to me. But I'm just one board member trying to run the meeting, so I'll listen to all of you. That's what I'm hearing, that we're going to have to come back with a new GDP. And
No, Madam
I'm going to
Chair.
ask, so we'll go down the line. Commissioner Whitmore.
Could she explain what she's saying?
Okay, I understand the attorney's comments, but I was prepared to stay here all night, and I, please, ma'am, you keep talking and laughing and clapping in the back, please. And it's just like here, I can't concentrate when I see that. But can you, I think we should make an effort at this. We all know what we want, and I don't think that, that I don't want to come back and we're all here today. Let's try to do something, not let's put this off for another date. Let's see what they can do. I understand, Sarah, what you're saying. I understand staff. There's two big issues that need to be changed. Tom needs to be there, our consultant, to see what we can do to make this right. Get rid of the estuary, get rid of the wall, get rid of, what was the other thing? There's three.
Change the phase.
Yeah, the phasing. And, you know, in common sense, phasing, and it was written 750, and maybe the numbers don't work, just put a number instead of phasing. I mean, that isn't that hard.
Right, well, I
wanna
think what
keep
I would
going.
like to do is to try to take a break and try to see what we can do. However, I do think that we need to talk about this wetland enhancement area, estuary enhancement area, which is now actually a wetland mitigation area. And we do have to talk about where the wetland mitigation is going to be. So maybe it no longer becomes an estuary enhancement area, becomes a wetland mitigation area, and it's beyond the buffer. And it is, this is kind of what I thought all along about it. If you're talking about basically a retention pond and a fill source, it can be built on the site. We allow those. We don't allow them in a buffer. And we do allow mitigation in them. Happens all the time. If that's what we're proposing to do, then we're just talking about moving it. And that's what I think we're talking about. So I think it's worth taking a break and seeing if we could do that, just move it and not make it an estuary enhancement in area, to call it what it really is a retention pond and a fill source, whatever you want to call it, lake.
Madam Chair, to be clear then, you're talking about moving the buffer for wherever they wanted to in the estuary, move it east into the property?
To have a buffer from the
Okay.
coastal wetland, like our comp plan requires, moves that lake out of it, and it keeps it,
Yeah.
but it's not an estuary enhancement anymore.
Retention pond. Okay, got it.
It's a lake. That's
Big
my
lake.
thought.
I'd like to hear from the
Others, other thoughts?
Madam
You guys
Chair,
want-
I would like for the Assistant County Attorney to clarify what she means. If we decide to do what she's doing, is that something that can be done today?
Okay.
We're going to try.
Well, the applicant's attorney has stated they're proposing changes to the general development plan. So what I'm asking is not to do that by stipulation, to have them submit the plan with the changes they're agreeable to into the record, because this is like a court. And the evidence isn't by stipulation. The evidence, what it is, what it is. It has to be shown in the GDP, where the wetland buffer is, where the wetland mitigation is. Your staff and your consultant, wetland consultants indicate they need that level of detail. You take off the detail. We're going to be sued over the old plan, is what I'm going to say. And we're going to waste time. We have to hire expert witnesses to defend this old plan. That's what's going to happen.
You know,
We have to have the plan in the record. It's what's being approved. This is a high-profile, highly litigious site, and we need to do things properly. That's what I'm suggesting.
Can it be done today?
If you need it longer than a half hour?
The applicant will have to, I can't draw the plan for the applicant. I can't even answer that question. The applicant will have to submit the new plan. They will have to open public comment on it.
We're going to give it a shot. We're going to give it a shot because we're all here. We'll give it a shot to see what can be agreed upon, to see if there's anything that can be agreed upon, or if we have to have a continuation day, we're going to come up with a realistic continuation day. We're going to take a half-hour break. If we cannot do it in a half hour, then they'll come back and let us know. Is that okay with everyone?
What about an hour?
Madam Chair,
I know. I understand that y'all
Sir,
don't want to
please.
stay longer than you have to. I understand that. But
Sir, please, please, please.
please,
Madam Chair,
everybody, Commissioner Smith, you still have the floor.
thank you. What I was suggesting, if this is something that can be done today, even if we come back at 2:30 or 3 o'clock and get it done. 30 minutes, if they can't get it done. We close to lunch,
Yeah,
what I'm saying.
1:30.
Okay, well, what I'm hearing from the county attorney is that, in fact, what she's saying is that they need to submit a new GDP that needs to go through a review. We're not talking today. But what we're going to give the applicant time to talk with the county attorney, see if there are stipulations that this board is willing to accept. We probably, if need be, will open it up to public comment. We've heard from, at a daily basis, we get at least 20 emails on this. We have heard from the public. We know the concerns. What we're trying to do, as we try to do with every application, is try to make sure it meets our comp plan and our land development code. We've told the applicant where we don't think it does. They're going to try to make it happen. And we're going to,
Resume the public comment for future.
and at the
agenda items.
end of the meeting, we'll resume public comment for
Why can't
future
we do
agenda
it now
items.
before
No,
lunch?
absolutely not. We're following our procedures. So, we're going to take we will be back at 11:30. At 11:30, we'll know whether or not we can move forward, or we're going to have to go to a continuation public hearing date. So we will be recessed until 11:30.
Get that every meeting.
Okay? Thank you. We're back in session, and I appreciate everyone giving time so that we can determine what the process is going to be moving forward. It's my understanding that we've had a request to continue this break until 3 o'clock this afternoon. The applicant will be submitting a revised plan, I've been told, so that there can be consistency between the plan and the stipulations. I don't know what will happen at 3 o'clock because we've not seen this plan. This is a little unusual. But we have been asked if we could wait until 3 o'clock when we can have a plan, we can have stipulations that we can look at. We don't know whether or not we'll have to open it to public comment at that time. It depends on what they propose. So that's where we're at. The county attorney has recommended that we do not take action by just putting stipulations in the approval, that it has to match the plan. So I beg your indulgence. I know this is highly unusual. I hope you all will hang out, go downtown, have lunch.
Long lunch.
And again, till 3 o'clock. So that is the request. Is my board okay with that?
I think that was my recommendation.
I think that was, Commissioner Smith. You were pressing it to see that as being the recommendation.
I'm still
So,
asking, since they're all here, to finish out public comment
Okay.
on future agenda.
Actually,
Agenda.
that's not a bad idea. Why don't we come back at 2 o'clock and we'll finish public on future agenda items. I am going to warn
Right
people.
now.
Right now?
Finish
You
it
said
now.
30 minutes, so I'd come back at 2:30 if you're coming back.
Well, I just want to make sure we had enough time. We only have 20 minutes before lunch break, and you guys don't want to go past the
We
lunch
can do
break.
30 minutes.
No, we can do,
Get the 30 minutes out. of the
We
way.
All
can do
right.
30 minutes.
Everybody want to go 30 minutes now? Finish public comment?
Yeah.
Future agenda.
Future agenda. And again, please, we know you all want to comment on the public hearing item. So please keep your comments on something that this board could consider on future agenda. So far, people have been pretty good with that.
I'm under 3 minutes.
In
so
3
more people
minutes.
can talk.
So I'll go ahead and open it up to the folks that were lined up before that would like to comment and future agenda. If you already commented, you don't get an opportunity. But please come forward and state your name for the record, and
And,
you'll have
if
3
you-
minutes.
And if you don't want to take your 3 minutes, it makes it more time for
People
the
can talk.
others.
So we'll be breaking for lunch at 10 after 12, roughly.
Hi, Commissioners. I'm Jack Merriam, and I'd like to request a future agenda item to discuss completing an adaptation plan similar to the one completed by the city of Punta Gorda in 2009 and that the city of Sarasota is currently working on. This plan should begin with components including an assessment of vulnerable infrastructure with particular emphasis on so-called green infrastructure, such as coastal wetlands, and living shorelines, including mangrove forests, as well as water and sewer plants, hospitals, and roads, classical infrastructure. I believe that living shorelines are more resilient to storm damage and afford us greater protection than hardened shorelines. We need to work with all relevant permitting agencies to facilitate and incentivize the preservation and construction of living shorelines and other green infrastructure. Right now, it's difficult to do. Hurricanes Harvey, Irma, and Maria have sent us a warning that we need to do planning for adaptation. While we must begin the process of developing and implementing an adaptation plan, we must also immediately protect and preserve coastal wetlands, especially mangrove forests, in our rivers and our bays, as required by the Comprehensive Plan and Land Development Regulations. And we must encourage the use of this green infrastructure rather than hardening more of our shorelines and filling our wetlands. Thank you.
Thank you.
I'm Shannon Larson, and I would like to have as a future agenda item is, based on what I'm going to say, Aboriginal and Indigenous people, holy, sacred grounds are worthy of the same respect as given to any other group of people. Discussions should begin on the rightful protection of Aboriginal, Indigenous sacred places and sacred holy burial grounds, graves, or cemeteries to you. It must be realized that it is not appropriate to remove burials and their belongings of those buried within Aboriginal, Indigenous burial grounds. In the Christian religion, we have heard the words, "Do not defile the dead." Yes, you have a code that supposedly protects Aboriginal Indigenous people's graves. However, you also mention data recovery as a means of protection. That is not protection. That means that Carlos Baroff could choose that way to go and go in and drag out.
Madam Chair, we can't
Children.
have
Order.
individual attacks right
I'm
now.
sorry, that
in
means
general.
any developer has the right to remove Indigenous peoples' burials under the data recovery. Data recovery was done in order to provide archaeologists with another job. It's an economic benefit to them. And when they do that, people like Bobby who have to go back and rebury those things, very often on the same piece of property that they were taken from, he never receives all of the little baby bones back. He never receives all the little aunts and uncles' bones back because they've been given to another university to study. So we ask you today to clarify that what is going to happen henceforth is proper protection of their grave sites, that you do not get rid of that data recovery thing. The Department of Historic Resources and the Compliance Department have not made a statement. I talked to Compliance Department yesterday saying that you can't put the archaeological sites on the General Management Plan. And anyone that wants to know where the sites are can call them. You have to make an effort sometimes, too, if you really care about these people's graves. And I hope you do. And if you do allow that data recovery on any of these sites, and people like Bobby have to come and try to fight to put them back into the ground, you're going to be held responsible. You're going to be held responsible for what happens.
Thank you.
Catherine Edwards. As a future agenda item, I ask the commissioners to consider the establishment of a local ethics committee. The state has the Florida Commission on Ethics, but that didn't stop the Florida House from establishing the Public Integrity and Ethics Committee. A local ethics committee would give the public a voice without requiring a lawyer and deep pockets. It also provides covers for the commissioners who are acting in good faith. This is especially so when we have developers making contributions to commissioners from 19 different LLCs, all at the same address, to circumvent the $500 campaign limit on contributions. Thank you so much.
Larry Grossman. I would like the commission to consider, as part of the update to land development regulations in future meetings, 3 items. Strengthen the GDP submission requirements for large projects. It's extremely important that the public understand what is being proposed for major projects and how these proposals might impact their quality of life. We must graduate from bubble maps and use innovative technical resources that are available to virtually depict in 3D what a proposed major development would look like and how it may physically and operationally affect neighboring areas and the community. This is particularly important for increases in building height in major mixed-use developments. Towards this end, I would ask the Commission to direct staff to do a survey of comparable land development review procedures in other jurisdictions and to examine computer-generated visual tools that might be helpful in understanding a proposal and to report to the Commission and to the public on their findings. 2, require an applicant who wishes to submit a large project to meet with affected neighborhoods prior to submitting a formal application and to not prohibit or discourage continual public dialogue with the staff and with the applicant during the application process. 3, consider requiring a transportation demand management to mitigate traffic as a requirement, as an LDR requirement. Such strategies would be binding on the property and would run with the land. We really can't continue to add more development with a constrained road system that really cannot be widened without having enormous adverse effects on surrounding neighborhoods. It is time to look at demand management rather than demand accommodation as your primary objective to control traffic impacts. Thank you.
Thank you. Please come forward. State your name for the record.
Hi, Joy McIntyre. Mine's not anything like what you're talking about. Has to do with what Robin's speaking. I live in the South District, and my concern is our aging infrastructure. All the building going on, can keep going. I said, but I've lived here a long time. There's a lot of old developments, a lot of old piping. Our traffic is a problem. And the rainstorm that we had 2.5 days prior to the hurricane kind of showed in our area, I know for sure, because since I live there, that we couldn't handle all that water. My house particularly didn't flood, but I have a sewer connection at the end of my driveway, and that great big iron lid actually lifted. It was lifting this way with water coming out. I have just a few feet from my house is a drainage ditch that goes right out to the bay, so there had to have been sewer going out that way. We had trucks running a day, at least a day and a half, over 24 hours, back and forth from the lift station that overflowed at Bay Shore. I'm assuming they were taking it up to the sewer plant. I followed some trucks that went to, like 3 or 4 o'clock in the morning, that went over near Wild Oak Bay. There was some flooding over there. I don't know exactly what it was. It was early in the morning. The trucks woke me up. That's because they kept running. I live near a 4-way stop, so they just were running. So my concern is we need, while we're building this, to make sure we're addressing our old infrastructure. Thank you.
Thank you. Want to state your name for the record?
Hi, Andy Melee. I'd like to propose a future agenda item or perhaps workshop or both related to the way the comp plan and the LDC are interpreted by staff, by commissioners, and by the general public. To wit, virtually everybody I talk to feels that the proposals that come out of the commission are approved by the commission are flawed. Flawed with much too liberal interpretations of the comp plan and the LDC, such that the developers get deferential treatment. It is felt, and the public is left with the choice to pay buckets of money to go to court or just suck it up. This could easily be circumvented by allowing the public access to some of the negotiations while they're going on. It is my understanding that we are, and I quote, prohibited from being part of months and months of negotiations that occur between applicants and staff. I believe that all parties would be well served with an inclusion of some representatives from the public at the table. And I would appreciate some consideration of that. Thank you very much.
Thank you. Anyone else?
Barbara Hines, Vice Chair of Minnesota 88 and Holmes Beach resident. I have several things. First, I would like to commend the county under the leadership of Robin DiSabatino for the response to the hurricanes. When we were sitting in Raleigh, it was awfully nice to get her up on the computer, and we felt better. So I want to say thank you. We also want to adopt Jack Merriam's testimony on mangroves in the interest of time. But in addition, I would ask you to at least study the effect of only having your staff meet with the developer. You say you're quasi-judicial. Well, I have never seen a court that had the person who had access to the judge or the jury only deal with one side and cut the other side out. We're lucky in this area because we have a lot of scientists and others who are world-class, nationally known and or known in their state. You can get so much good information, and your staff could, But project manager, and I asked her after the vote, I said, why did you not have everything filled in? She said, because the developer didn't. And I said, and why didn't you? And she said, I was told to put down what the developer submitted. Now, I don't know if it's true or not, but I can tell you who she is, and she is no longer, she's gotten a better job now. And I also asked her, when was the last time you were out on the project? And she said, oh, I haven't been out there. And I said, well, why? She said, because the uplands were so full of water that our Jeep could not make it. Now, so I want you to at least seriously consider having a fair process that takes advantage of all of the good resources that you have, and you don't even have to pay for, from people who have nothing to gain except a better environment. And there's a word that you don't seem to remember: cumulative impact. Because time after time, you look at one little area and you don't think of the cumulative impact on others. Thank you.
Thank you.
Hi, Richard Maggio. In any large project that involves sensitive lands, the developer it behooves him to try to maximize development, to use as much of the property as possible. And that's why we have a staff, the environmental staff, that takes a look at the project and tries to determine what makes sense and what doesn't. And very often there's a little bit of give and take. And part of that give and take is there may be a mitigating project that's recommended. And sometimes the staff will say, let's mitigate the potential damage to the wetland, for example, by building a pond or something else. It behooves the board to get on the same page as the staff before presenting these kinds of things to the public, because it would make sense for you to know what they've already recommended and why something is on a plan, instead of discussing it in a forum like this. They've already made these agreements with the developers. You should know what their agreements are before facing all of us. Thank you.
For the record, Glenn Giabolina, taxpayer and community activist. So I want to again thank Robin for a great job on the Irma thing. We've changed attorneys. I don't know why. I kind of like the last one was there. The current attorney is pro-development, so I would object to him being there.
No personal attacks.
I was here a month ago, and I'm going to sound like if we can get that on the overhead, like a broken record. And one of them would be public comment cards, electronic public comment cards. I've been asking about this for a year. Carol, you told me to wait for the budget. I've waited for the budget. I've yet to receive a answer. The PACE program, God knows we need hurricane protection. The PACE program implements a homeowner to put hurricane shutters, make the proper repairs to their home, and just put it on their taxes for the next 20 years. What is the big deal? I mean, this should have been done months ago. I've yet to see an answer like that. So glad you didn't stop my clock yet. So.
On a minute.
Yeah, I'll be here all day.
2 minutes.
Seating.
1 minute has gone by.
You know, seating, I've talked about the seating. You don't even meet code on some of these seats. New River High School, we need to pay for the difference on hardening that shelter. Talked about government buildings. Today, the Manatee County does not own, well, they may own them, but they certainly don't open it to the public for hurricane protection. This building being one of them. I think you can get 30 or 40 cots up on the 4th floor, if I'm not mistaken. You don't even open it up to your own employees. State built, where I live, of course, concrete plants on both sides of us, not regulated by the county. And, we're miserable out there. I'll bring this up again, 7 commissioners. I don't know why we need 7. Most counties have 5. I think we could save some money there. The Confederate statute, I've brought that up before. Where is it? who's doing the repairs, and where's it going to go? So we haven't had that either. Affordable Housing Fund, I did several requests on where that money is. For months, I don't know. Apparently, since 2006, we've been sitting on $3.4 million. So I don't know what's happening with that money, but it certainly could be used to build affordable housing. The bike path, the number one bike path, was taken off the route. And Ed Golf can attest to that, and I would like to know why that is. The jack systems, you know my feel about the circuit court, we should defund it. The point is, this letter, I'm just scratching the dates out. It'll be like a broken record. I've yet to been able to cross one of those items out. Is that an effective government? Can you give me one answer on these questions that I've been asking for over a month? And I'll be back in 2 weeks with the same list, just scratch the day out. So get used to this broken record until I get some answers.
Thank you. Please come forward, state your name for the record.
David Woodhouse. I have a lengthy background in geology and meteorology. It is my belief at this time that we are entering a period of more hurricanes, some of which will contain catastrophic winds and tidal surge. How did I arrive at that conclusion? I used to work on the siting of nuclear power plants on the ocean, And we used to study what they call gravity maps. And the gravity is based on the density of the rock that's underneath us. And believe it or not, when you look at these gravity maps, you see a highway that runs from Africa right through where we live, and then it goes on to the west. And hurricanes, they follow, believe it or not, roads underneath the ocean. And for that reason, I believe that we are in a hurricane cycle right now. With that in mind, the board should consider a future workshop on climate change in relation to future developments on the Sarasota Bay, which will be vulnerable, and they should also consider the filling in of wetlands, which are natural sponges for the amount of rain we get. We just had 20 inches of rain in the area I lived in, that's by Tara and Route 70. There were cars floating down the road. We don't have an infrastructure to handle a lot of rain. And to continue building out areas that have natural sponges or areas that could be flooded by a tidal surge, and I'm talking about a wave 20 feet high. And we should not be considering developing anywhere on the ocean or bay, however you want to phrase it, without having something in mind that this could be a very vulnerable area. Preserving the mangroves and wetlands is critical in such high hazard areas. Again, we should not be sticking our nose out at Mother Nature. Mother Nature gets very mad, and I think we're finding this out right now. Houston filled in their bayous. Well, where'd the water go? Look at Katrina. New Orleans was built underwater. And finally, I'm just going to divert the subject a little bit. Mexico City just got wrecked. Well, Mexico City was built on a lake which was underlain by soils that turned to liquid when shaken. So we had an earthquake, the soil disappeared, and then there go the buildings. So I guess the bottom line, I'm just trying to tell you that, there's a lot of lessons out there from Houston to New Orleans, even to Mexico City, that we should really be looking at future developments. Thank you very much.
Thank you.
Boy, that's pretty good, huh?
Very good. Good timing.
You get an A.
All right, anyone else who wanted to address the board on a future agenda item? Now would be your opportunity. Okay, seeing no one come forward, I'm going to close public comment on future agenda items. It's now noon. We're going to break and be back at 3:00. We're recessed till 3. All right. Thank you, everyone, for returning. It's now 3 o'clock, according to my computer, so we're back in session. I'm waiting on Thomas Gerstenberger to get back with a plan. I understand they're printing it now, so I want to give the board members at this time an opportunity to make board comments. We did hear a lot of future agenda item suggestions, so I know I've got a comment about one that I heard, but wanted to ask if anybody else wants to make any comments at this time. Push your buttons. Whoops. And turn off your phone, please.
Dog does.
Oh, my God. All right, well, I'll go ahead and go. We had heard about the shelter issue, and this is an issue that our board did discuss in a work session. As I think some of you may be aware, Manatee County is part of the Tampa Bay Regional Planning Council. And the Tampa Bay Regional Planning Council is charged with evaluating shelter capacity. And based on the most recent analysis done by the Tampa Bay Regional Planning Council, Manatee County has adequate, in fact, excess shelter capacity. We had a discussion about that, recognizing that we had a Category 1 evac, or Evacuation Area A, ordered evac situation. And luckily enough, we had enough room for everybody. But if it had gotten to a Category B evacuation, we would have had an issue. So looking at the information, John Osborne presented a study to us, and he was looking at the study as is currently in effect, and says, in fact, the reason we have excess capacity is because we're put in with Hillsborough County, and Hillsborough County has excess capacity. But if you look at the number of people that are evacuating, where they're really coming from is the south. They're coming here. We're not going to Hillsborough. The people from down south, Charlotte, Sarasota, they're evacuating north, because that makes sense. Usually, when hurricanes are coming, they're coming from a south to north situation. And that information is what the school board relies on, that study. By law, they can rely. When they came in for the high school, they relied on the study that's in place, the Tampa Bay Regional Planning Council study that shows there's adequate capacity. So we looked at that and had a discussion. And long story short, we wrote a letter to Manatee County School Board Chairman Charlie Kennedy, asking him to help us work with our legislatures to look at this, maybe change the study. Maybe we shouldn't be looking at hurricane evacuation from the Tampa Bay Regional Planning Council, because that's really not how evacuation happens. And also to try to help find funding for these new schools. So the other thing that is kind of interesting is the study, a new study has to be adopted in January. And we predict that that study, with updated population figures, will in fact show that we don't have excess capacity. So it's a technicality, and we're trying to work through that, but I guess my response to the gentleman who says that we don't do anything for hurricane and don't look at shelter capacity, not true. We're required by law to look at it, and we do, and we're following the law, but we think the law needs to be tweaked. So there will be more discussion, but I have a copy of the letter here that was submitted to Charlie Kennedy. We've not received a response. I know they're discussing it. We know it's also being discussed by the state legislature at this time. They're recognizing that we have some issues, so I did want to give assurance to the public who thinks that nothing is being done regarding hurricane shelters and capacity, that that's not true. Commissioner Whitmore.
And I just want to make a comment on a comment that Mr. Goff had said that about raising the levels of the homes to be built in developments. I know where he lives, and that was elevated for him to live there. So we know exactly where that was. And if they didn't do that, according to what our rules and laws say, he wouldn't be living there. So, I understand what he's saying, but this has been the practice for many years. And again, he wouldn't be living in the development he is if they wouldn't have done that.
Okay, any other commissioner comments at this time? Anything else? It doesn't have to be about what we've heard today. It can be anything else?
It can just be a regular
Regular commissioner
All right,
comment. That's
I'll
where
go.
we're at.
if you want me to.
Kind of waiting for the
Okay.
site plan to show up.
I don't know if the other commissioners have received any emails on this topic or not, but if you'll recall, a little over a year ago, this board had a discussion about increasing the speed limit on Lorraine Road. Staff had recommended going up to 45. However, this board left it at 35. Well, I have received several comments, most from residents that live in the Greenbrook area of Lakewood Ranch, wanting us to increase the speed limit again up to 45. And I don't think, they say it's a real inconvenience having to go 35, and most cars don't, and it's true. Most cars do speed on that road. It's a major issue. However, my thoughts on the subject have not changed. We did not, as I recall, increase the speed limit because many homes back up to Lorraine. And we all know that the faster a car goes, the louder it is. So there have been major complaints from residents that live that back up to Lorraine Road about all the noise. And I can tell you I'm getting emails now on both sides of the issue again, because some people in Lakewood Ranch are realizing that there's a group trying to increase the speed limit again. So it is a hot topic right now in Lakewood Ranch. It is probably something that before it's all said and done, we'll hear more and more about. However, at this time, I'd have to say that, I'm getting emails equally on both sides. So I just wanted to bring it up and let you know that it is being discussed again. In fact, there's y'all are probably aware, most of you in your neighborhoods probably have an internet program called Nextdoor.
Yeah.
Well, I was on that for Lakewood Ranch, and actually I was taken off, and it was because they were doing a petition on there to increase the speed limit, so they took me off of the program, I guess. They didn't want me to know they were doing it, I suppose. But I just wanted to let you know it is an issue, and, before it's all said and done, we could have people down here on both sides of this again. So just thought I would make you aware.
Can we dialogue with her?
Push buttons, please, and I'll let you speak. Commissioner DeSabatino, then Commissioner
What
Whitmore.
was the staff recommendation at that time?
The staff recommendation was to increase it to 45.
Your traffic study. That's what I was going to ask, because I
Yeah.
remember the 85th percentile, we're going 45 miles an hour.
And that's the other thing. The majority of cars on Lorraine Road, and I travel that road quite a bit, most people do speed, and the problem is if we increase it to 45, they're going to go 60. So, and there's, a school zone on Lorraine Road, and a lot of people, ride bikes on that road as well. I mean, I do. So it's not cut and dry. There's a lot of construction as well going on, and I think it might save you a minute going 45 rather than 35. So anyway, it is what it is.
Commissioner Trace?
Compromise and go to 40. Simple.
Well,
Nobody's happy.
Well, I think to do a speed limit change, we have to have a public hearing, right?
Yes, correct.
So, I've not read any emails. I got one, but I had not read it yet about Lorraine Road. I saw it, had not read it, so that's apparently what it's about. So I'm going to defer to the district commissioner at this point, is my thought.
At this point, I think it needs to be a good discussion in Lakewood Ranch among the residents themselves in Lakewood Ranch. So before I bring it forward for a meeting, I would rather get more people involved in the area on this, because I can tell you, I remember, and I'm telling you, I was getting emails. I mean, I was getting phone calls, everything. People were really against it being raised. So it's kind of like I'm sitting back going, uh-oh, bag of worms, here it comes again. So anyway, I'll let you know how it goes, but I did want you to know that that could be something that we might have to look at in the near future. So I'll let you know.
Okay.
Thank you.
All right, I just want to give a real brief report. I think most of you, well, some of you, attended portions of the 2017 World Rowing Championships. I had the honor to speak at the opening ceremonies and at the closing ceremonies. And it was an incredible event for our community that was carried off basically without a hitch, right after a hurricane. I had the opportunity the Wednesday before opening ceremonies that opened a week ago, it'll be 2 weeks ago.
Friday.
Saturday.
Saturday. And I had an opportunity the Wednesday before to take a tour. All of the board members were invited to take a tour, sneak peek of Benderson Park, the way it was set up, and Al Mayo and myself both attended. And it was incredible. They basically created a small city to accommodate 69 different countries, athletes, fans. The event was sold out on Saturday and Sunday. Everybody was, the FISA group which is the International Rowing Federation that puts these events on, and it was basically an Olympic-style event. The rowing is considered, the World Rowing Championships are the off year to prepare for the Olympics. The crowd was so appreciative of all of the amenities that were there at the park. The businesses were all very appreciative of the opportunity to showcase their businesses. Just a few facts, though, because I did have a reporter contact me. They were doing like an investigative report out of Tampa, and their facts were so incorrect about how Nathan Benderson Park was financed. So I'm going to read some of them.
I saw that, it was terrible.
Because
Trying to kill time.
I think it's important that the facts be put out there, and if the newspaper can't do it, well, then perhaps we need to. And this was Tampa Bay Times, it wasn't a local newspaper. Or, excuse me, ABC, whatever in Tampa. Whatever the
11.
station is, I can't remember. So, Sarasota County's capital contribution, $19.5 million bonded in 2011 from one half of one of the 5 pennies of the TDT bed tax. That's important. The story said, how can they spend so much of county taxpayer dollars?
Didn't spend any.
Well, TDT, tourist development tax, is not
Taxpayer.
paid by county taxpayers unless they're staying in a hotel in their community, then they are paying it. Because TDT receipts continued to outpace debt service, TDT funds have also been the exclusive source of funding for park operations, including maintenance and operation and events and marketing. Benderson family and the Nathan Benderson Park Foundation have contributed in excess of $16 million to Nathan Benderson Park since 2009, including the $6.85 million finish line tower. How many of you got a chance to go up in the tower?
How much for the finished tower?
$6.85 million. That's why it's named the Benderson Family Tower. You give $6.85 million, you can have something named after you. Additional contributions not valued are Benderson's staff time volunteered to the project and other in-kind contributions, including the use of vehicles, equipment, landscape support, and parking support between 2009 and ongoing. Absolutely. The Benderson employees, since the very beginning, have worked extremely hard to put on a successful event, and they worked again. I saw many of them that I know working again. And the volunteers that work at Nathan Benderson Park, coming from Manatee and Sarasota County, incredible. Some 1,800 volunteers is what they estimated.
Right.
Working the event. Volunteers, not paid, because they see it as such a worthwhile endeavor. State of Florida has appropriated $15 million over 4 budget years, of which $12.5 has been utilized for capital improvements to the park. Let's see, the last $2.5 million appropriated Nathan Benderson Park exclusively for the 2017 World Rowing Championships. Manatee County's contribution between 2011 and ongoing, based on this past event, is $1.75 million. Manatee County is unable to fund capital improvements in Sarasota County, but supports Sanka's operations equally with Sarasota County and Benderson. The TDT funds, again, that's what Manatee County used, transportation, tourist. I don't serve on that board, so.
I do.
Tourist development tax.
Bed tax.
That is what Manatee County has used to support Sanka. It's been marketing funds. So, again, just a few facts to tell about what was the funding and what was the result. The result is FISA said absolutely they will be back. We also have an international triathlon coming up in 2 weeks with athletes from 26 different countries. And I was thinking, you know, what better use of tourist development taxes than to showcase something like, you know, Nathan Benderson Park and bring people here from around the world. That is the purpose of those marketing funds.
Madam Chair, on that?
Are you on the board?
No, well.
Please push your button. Commissioner Bowes up first.
I just wanted to add, Commissioner Benek, with what you said, that when I was out there, it was a sight to see Randy Benderson out there working as hard as he could go, as fast as he could go. And I got to tell you, the poor guy was sweating as much as anybody else out there working so hard. So for me, I can tell you that it was amazing, and the response from residents that were there has been just overwhelmingly wonderful. It was a very wonderful event to represent the region, and it did. It represented Sarasota and Manatee County, both. And regionally, you couldn't have asked for more than what that was. It was fantastic. So I was very proud to have it in Manatee County and Sarasota, our sister city, and you know, it was really great. It was wonderful. Great event.
Absolutely. Commissioner Whitmore.
And we are giving our commissioner reports now because we're waiting for our staff to come down, because I saw a couple of people kind of wondering what's going on, and that's why we're doing this. But Randy Benderson is also committed, and this year the Making Strides Against Breast Cancer Walk with 20,000 expected. I'm co-chairing it. October 28th. I was supposed to be there at a meeting today, but couldn't make it. But we are doing that October 28th, and they're expecting 20,000 walkers. So, like you said, and it's regional. It's from Sarasota, Manatee, Tampa, everywhere, and they've been very supportive. And they're gotten all their experience from this World Rowing, that any event they're doing is going to be successful. So, we outgrew where we were at the polo fields in Lakewood Ranch. So last year we had 15,000. We needed a bigger place, and Mr. Benderson offered to do it there. So
That's great. Commissioner DiSabatino.
Oh, yes, it was great. I was able to go last Friday when I think I just missed Commissioner Baugh and Benak and Whitmore, and then myself got to give out some awards, and that was
Medals.
the medals. So that was really cool. With the pomp and circumstance, and it was just really neat to witness that. And I have to say that everything was very well coordinated with the buses to get you to and from the parking lot, and you know, they really had it down pat. And just wanted to thank them for a job well done. And I texted Randy on my way out, and I thanked him very much. And again, I see Joe McClash here. I always used to say that shopping center where they used to be, they're now across the street. But they tied in all the landscaping from the shopping center all the way over, and it looks really beautiful and really first class, and really proud that we were able to participate in that.
And just the economic impact as verified by Visit Sarasota for a total of 2013 through 2017 is $87,840,449. So it is a big impact, and so we will be, I will be presenting to the board what I accepted on behalf of Manatee County from FISA, which was a Medal of Honor. It was a surprise on Sunday, so I will be doing that at the first regularly scheduled board meeting. Okay, I think we're ready to go back to our public meeting regarding Aqua by the Bay. I'm going to turn over to Sarah.
Yes, Madam Chairman, you're being handed some revised stipulations and revised zone development plan, and the applicant's prepared to go over exactly what the specific changes are, and staff can respond to any additional comments they have on that. And then it'll go back to the board for any specific questions.
Okay, we'll go to Mr. Vogler.
So, my name is Ed Vogler. I have been sworn. The objective over the last few hours was to conform the plan drawing, which was just handed to you, to the stipulations that have been discussed during your deliberation. And so the objective was to make the stipulations and the plan drawing the same. And Misty Servia, our planner, will have a walkthrough with you on the very minor changes that are reflected in that drawing. I'm going to have a few comments about other impacts, and then we've got revised stipulations that have been vetted, I think, by everyone.
Thank you. My name is Misty Servia. I am a planner with King Engineering, and I have been sworn. So each of you has been given a copy of the revised plan, and it is 7 sheets. So what I'd like to do is go through it sheet by sheet and tell you what's changed on each one, okay?
Could you please make sure you have a sheet up on the overhead projector while you're talking? If somebody can just give her one of the plans so she can put it up so people, the public can see.
That would be helpful. Okay, so we'll begin with sheet number 1, where there were no changes. And we're going to show you what that looks like right there. No changes to sheet number 1.
You could zoom in a little bit.
Sheet number 2, no changes. Moving on to sheet number 3, that is L103 in your set. And let's start on the left side of the page, so hopefully everyone can walk through this with me. On the legend, we have removed the reference to the wall location and to the estuary enhancement area. Beneath that, under the minimum setbacks, we have removed the reference to the upland retaining wall on row 7 of that chart. Moving to the right, under the estimated acres table that you see in the middle, we have revised the wetland impacts from 13.29 acres to 7.93 acres, okay? In the drawing itself, we've removed the estuary enhancement area, which was shown in blue. That is now gone, and we have removed the upland retaining wall. And what we've done in its place is we have extended the colors that were adjacent to those areas to fill in that area, and that is because they were all uplands, okay? Beneath the illustration, you'll see there was a reference to an estuary enhancement area to be built in Phase 2. That is now gone. There was also another reference on the right bottom side of the page to the estuary enhancement area, and we have eliminated that. Those are the changes for sheet L103. Sheet L104, on the left side, note number 4, we have changed the total wetland impacts from 13.29 acres to 7.93 acres. Okay? On this sheet, we've also eliminated the typical section that once showed the estuary enhancement area. That's gone. Sheet number L105, no changes. That was the aerial, okay? Moving on to sheet L106, no changes. And sheet L107, under the legend, we have removed the reference to the wall. We have removed the reference to the estuary enhancement area. We have shown the 50-foot post-development wetland buffer up against the wetland line. And let me also say, I neglected to tell you on sheet L103, we did the same, okay? We moved the post-development wetland buffer right up against the wetland line. So now there is a consistent buffer from the wetland. And those are the changes.
Questions on the changes to the plan? Buttons. Commissioner DeSabatino?
Right now, because it's all hitting us, but I just have one question. What percentage of open space are we dealing with now? Is it reduced because you reduced?
There's no change in open space.
Okay.
All the estuary.
So, Madam Chairman, I'd continue if you're, unless there are other questions at this
Yeah, I
moment.
just wanted to ask on the plan that Misty, if anybody had any questions.
But I still see like phase 5 and 6 on one of these sheets.
Yeah.
Are there 5 and 6 phases now, or the 4 that you were recommending earlier?
So there's always been construction phases.
Okay.
Because those are required to be shown on a general development plan. Those have not changed. But the nature of the planning approval, the wall effect stipulations, and the other things that we're bringing back in phases, those have been, will be affected by these stipulations that would be consistent with the plan, and that I'll review with you. And if you're satisfied, then you would understand that that's how that would go together.
Okay.
Okay.
All right, my name is Ed Vogler. I have been sworn. I'm going to draw your attention to Note 3, which is on L104 of the drawing, just to explain a circumstance. If you noticed from what's been presented so far, the elimination of the estuary enhancement area has reduced the wetland impacts from roughly 13 to 7, roughly 6% reduction in wetland impacts. 17 to... 13 to 7. So, we have reduced the wetland impacts, and the data on that chart reflects that. And when that happens, under a very, very complicated density formula that is set forth in Note 3, that would allow the applicant to seek additional density. Because under the density transfer provisions, there's a reduction under policy 2.3.1.2 when you're impacting wetlands. So in essence, you're allowed to transfer less density when you impact wetlands than you are when you're not impacting wetlands. But that's merely an explanation, because the good news is we seek no additional density as a result of that. But wanted to make sure that the clarification on the methodology of the calculation was understood. And so the requested number of residential units has not changed, has not. But the complexity of the formula has changed a little bit, but we're not taking advantage of that. Is that understandable?
Yes. Questions
to me.
Question. What could be the maximum density with this new calculation?
Well, I've done a quick calculation, and I believe that it would be 50% of the roughly 6 acres, so 3 acres times 9, if all of it was in the 9, and I think it is, and that would be 27 units. So it would be between 18 and 27 units, give or take the fraction.
Okay, please continue.
So, all right. And so we've also presented to you a revised applicant's recommended motion with revised stipulations, which are 18, 19, 20, 21, and 22 as recommended by the applicant. And the process that resulted in developing these commenced this morning when we said, we make these commitments, and we will use words to express them in a way that is clear and transparent. We now have updated the plan to reflect these. And A18 is the exact same phasing concept that we had talked about before, different words. When you get to 750 residential units, we will need to come back to the board for approval at a public hearing for the next increment of units. And this will continue throughout the project build-out. And there will be public hearings, and there will be plans, and they will be detailed. Even though we have removed the estuary enhancement area and wall from the plan, we wanted to make sure that everybody understood and knew, so we allowed for the language in A19, the estuary enhancement area and the wall are stricken and removed from the general development plan in their totality and shall not be built by the applicant. We believe that is clear. Stipulation number A20 states that stipulation A8 is hereby deleted. Commissioner Banach, if you'll recall, this was an important point to you as it related to the development footprint as it relates to the wall. And it used to say that there'd be so many feet from the wall before there was any development, but there is no wall. So as it was pointed out to us, that should be deleted, and we've proposed that. So also, in response to some of the comments that we've had this morning, so that there's no lack of clarity, A21, a uniform post-development wetland buffer of greater than 50 feet shall be provided adjacent to post-development wetlands along Sarasota Bay. So I think that leaves for no ambiguity. And then if there was still any ambiguity, we have proposed A22, which states that all stipulations shall prevail over the general development plan drawing, which has been what I've mentioned as the course of proceeding for a considerable period of time, and one that we're comfortable with, and we hope that you are as well. I'm not going to make a summation. You're in deliberation, and we're answering your questions.
Thank you.
And we're not presenting additional evidence at this time.
Thank you.
Madam Chair, may I just ask Mr. Vogler one question? Can you please confirm whether at each preliminary site plan level of review, the applicant will be complying with the comprehensive plan and LDC provisions regarding wetland impacts and mitigation?
Yes. At each preliminary level of review, the applicant will comply with all wetland impacts review that is consistent with the Manatee County Comprehensive Plan and the Land Development Code. Yes.
Okay. Commissioner Whitmore.
Okay, Mr. Vogler, I'm just gonna make sure I've got all this straight. No, there's gonna be no wall effect when you present the schematics of the buildings, correct?
Yes, there's an existing stipulation on that.
Exactly. The highest building will be 95 feet, compatible with the Lake Flores development next to us, and there's approximately how many buildings that are 95? 4?
Potentially 16.
Okay, oh, that's right, I'm sorry. Okay, there was 445 feet.
Yes,
though.
ma'am.
Okay. There's
Those are
no
a distant memory.
145-foot buildings, correct?
Correct.
The estuary's gone,
Yes.
the wall is gone. The wetland impacts went from 13% to 7%.
Acres.
Acres, sorry. Well, acres, okay. And then no additional density.
Correct.
Comments on the planning commissioners that had voted against it was the variable width buffer and building height. That was Mr. Bauer. That's gone, right?
Well, I
On
don't
the
know
current.
I don't know what Mr. Bauer would have
Had their
supported,
notes. Yeah.
but they are gone, yes.
Harrigan was the variable width buffer. That's gone.
Gone.
Rhodes was the 145-foot buildings, and that's gone.
Yes.
Okay, thank you.
Okay, Commissioner DeSabatino.
Yeah, well, I was going to ask that on page 2 of the staff report. It has the chart, the table of the building product types. And again, you're saying 16 95 feet tall buildings. And then an unlimited amount of buildings, 36 to 75 feet. Is there any rough estimate of how many buildings that would leave in the up to 75 feet category? I'm just curious of, you have to have some kind of calculation.
I think that the testimony of the architect, which is in the record, and we're not in public comment now, was that that would come about by project design. And so we don't really know the number of buildings, but what we've done instead is we've limited the height, and we've created a no wall effect commitment, and we've agreed to bring it back to you.
And also, I guess this is either a question for you or Gerstenberger. Since you're not building the wall, you'll still need to have a grade of ramping up to your 13, 14, 15 feet. So that, you have that like 4-to-1 calculation. Is that true, Mr. Gerstenberger?
That's the maximum.
Madam Chair, Commissioner Madam Chair, Commissioner Sabatino, that would be correct. In lieu of the vertical retaining wall, there would be a transition slope. The maximum gradient or steepness of that slope would be 4-to-1.
And about how far now from, how far back would the buildings need to be set back from the water?
I think previous testimony I gave that on a 4-to-1 transition slope, that to reach the proposed grade, which is somewhere around 13 feet, that would take roughly 50 feet to get there horizontally.
Okay, so 50 feet from kind of like the crest, where you go up from the crest there and then 50 feet to the buildings?
Basically from, or essentially from existing grade up to proposed grade. The transition, the minimum transition, if provided a 4-to-1 slope, would be 50 feet.
That's all I have at the moment.
Commissioner Trace?
Yes, I'd just like to hear from the county attorney and planning staff. The changes, are we recommending this, or do we have problems or any issues whatsoever? Staff?
Yes, for the record, Nicole Knapp, and I have been sworn. Staff met at 2 o'clock to look over the changes to the GDP and the proposed STIPs, and we have not changed our recommendation of approval, and we now concur with the new STIPs. We're comfortable with the new STIPs and that they support the new GDP.
And our environmental consultants happy? Better, worse?
Tom Pride, I have been sworn. Yes, Commissioner Trace, I agree with Nicole's statements.
Okay. And Sarah?
I have no legal objection to the revised stipulations and the revised general development plan as long as they've been made consistent with each other. And the final procedural comment would be that it's up to the board whether you take public comment on these changes, but you have the ability to limit it to these specific stipulations. And if you do so, the advantage of doing that is it protects you from a denial of due process claim by third parties. So it's up to you, but the chair, I think, is prepared to limit the comments if you so desire.
Yes, I'll go ahead, and I'm actually next up, and I'll respond to that. You know, we're accepting a revised general development plan, if we do this, and stipulations, and they specifically address two issues: the estuary enhancement area and the fact that there's a little bit different phasing on the units, slightly different. It's not called phasing, it's the fact that they're going to come back. And on the height and number of buildings issue, I think one of the things that I've been thinking about, and everyone is concerned about the number of units, but this project was approved previously for buildings over 35 feet in height, and it was one phase, one very smaller phase. And I don't recall how many buildings were in that phase, but if you were to multiply that across this entirety of this site, my guess is there were probably close to 16 buildings approved already previously. They weren't at 95 feet, they were a little bit shorter. They were at 5 stories over floodplain, I remember that. I don't know if anyone can correct me on the number of buildings that were on that plan. I did ask, but I asked an attorney and he couldn't remember. So I don't know if anyone has that information, but I think it's misconstruction to say that there was not a number, quite a few, intent for quite a few buildings to be on this site. I wanted to clarify that. Sabatino?
Yeah, that segues into what I was going to ask. So currently, their max are 5 or 7 stories. And so now this 95 feet possibility, and then you're going to add the 15 for base flood, so you're at 110 feet, and you're having 16 of those buildings. Is that correct?
Commissioner DiSabatino, that's not how the definition of height works. Height is taken from the grade of the building, not from base flood added on. So you don't add 12, 13 feet to the height of the building. The height of the building is 95 feet. Max, not 95 plus 13.
Just curious, maybe you would know or Tom would know, what's the base flood elevation of Elcon?
Lower. The road?
So, because you're looking up, because it'll be higher, closer to the road.
Commissioner, are you referring to the grade of Elcon itself, or
Yeah.
the grade of El Conquistador is at or above base flood elevation in this particular area, so at 12 or 13 feet.
Okay, so the base flood elevation of these new buildings will be higher, the base flood is higher than the road.
13.
Elevation would be consistent with the road elevation itself.
Right.
Because the the base flood elevation is consistent, whether it's this project or for El Conquistador Parkway at 12 or 13 feet, base flood elevation.
And I would be in favor of anyone who wanted to speak on citizen comments about these specific issues. Thank you.
Okay, how does the rest of the board feel about taking public comment at this time?
On the issues that,
On the issues specifically, so we're not gonna hear about traffic, we're not gonna hear about, I don't know. We're gonna talk about the two issues, which is the phasing of the site plan coming back to preliminary site plan after 750 units, and the removal of the estuary enhancement area, and the wall, and having a buffer greater than 50 feet. Those would be the only comments that we will entertain, because those were the only changes from what we had a public hearing on before when we took public comment.
I'm in favor of the public comment
Me too.
on the stipulations.
All right. Okay. I see a majority saying they're okay, so I'm going to go ahead and open public comment. Portion, please come forward, state your name for the record, and whether or not you've been sworn. Let's all get sworn in. Anybody who's going to speak, please stand up and get sworn in, because this is still a quasi-judicial public hearing.
even if you don't think you're going to speak.
Do you swear or affirm that the factual statements and factual representations which you are about to present to this board will be truthful and accurate?
Thank you. And unfortunately, I don't have people signed up, so you're just going to have to line up. You did good this morning. So if you just all would line up and state your name for the record. And, yep, and if you just agree with the person in front of you, you can say you agree.
And if you want to use lesson 3,
Hi, my name's Dan Young. I live at 7215 Broughton Street. I'd like to be.
And I have been sworn.
I think it's good that I'm first here. My first question is, don't you have to advertise or let the public know if there's availability of public comment? Because you've just said there would be no public comment at this meeting, and now I'm here standing. I didn't intend to comment. The second point I wanted to make was this confusion over basic elevation. Will the road that exists there now, the very inexpensive one that was built that snakes through, it's kind of nice, will that be below the grade of the site? And if so, how far below the grade of the site? And please don't make reference to the base elevation. Just above sea level will be fine for me. If you want to use mean sea level, that's even better. There was a lot of confusion in the hurricanes about what storm surge was and what the elevation of storm surge was. These things should be made clear to the public, not be hidden with run because the water's coming, okay? Thank you, that's all.
Thank you. Please come forward and state your name for the record and whether or not you've been sworn, because we are in a quasi-judicial public hearing.
Not going to answer his questions or anything, I guess?
No, not until
After,
public
okay,
comment is done.
great. Name's Andy Mealy. I'm representing Sierra Club. I have been sworn. Thank you very much. I also have a question. Since you guys were actually talking about the building height, it'll just be a question, very brief. What is the significance of the 35-foot height limit
That wasn't on
in
the,
coastal development? Yeah, but you guys were just talking about it just a minute ago.
Please continue.
Okey doke. All right, to the wall. The wall was originally going to essentially house the outfalls of 5 major stormwater, either ditches or pipes or square culverts or something, one of those things, draining not only the Long Bar Aqua site, but also a significant portion of Lake Flores property as well. Absent the lagoon canal thing that was going to be there, which was actually going to be like the mixing zone, and it was going to then flood fresh water over the mangroves and everything. How is that water going to be treated? Where is it going to exit? Is it going to be run all the way out through the mangroves in pipes, or is it going to be dumped right on top of the mangroves? Is there an analysis of what the impacts of all that fresh water are going to be on the local ecosystem, the marine ecosystem right outboard of the mangrove fringe? Or, there's some serious questions that I would like to have addressed on that, because they're kind of a showstopper for me. Thank you.
Thank you.
Ken Jablina, and I have been sworn. This is a very, very important decision. I think we need to step back and take a look at it. The problem that I have is that this is a major revision of this project. And I agree with the first speaker that the public needs 3 days of notice. A lot of these people left today because we're going to cut public comment off at 30 minutes, and then we'll come back at 3. Then we took a half-hour break, and we finished up the public comment at 11:30. It was very, very confusing, and it wasn't fair to the people that left. They should have an opportunity to speak of this issue. The second issue I have, probably more importantly, is that you all got copies of these revisions. Did the public get any copies? Could you even read it on there? I would venture to say, if I go back on METV and look at that sheet of paper, you couldn't read it with a magnifying. So, as Mr. Vogel had stated, and he's an attorney, and he would know this, if he is reading something and it's not verified by the public, or I can't see it, it becomes hearsay. And that's exactly what this conversation was. It's hearsay, and it's not admissible into the records without the public having the access to read it, to review it, and to look at it. I think if we had, we postpone this meeting for another month, we bring it back to our experts and say, really, what is the environmental impact on this 50-foot? What is the grade? And I would question a 14-foot grade in 50 feet. I mean, this building's about 50 feet, and that's more than 4 to 1. I will guarantee you that. So there's a lot of unanswered questions. You're trying to ramrod this through at the last minute, and it's unfair to the citizens that have major concerns. You saw the turnout this morning. We can have that turnout again. We're just asking for an opportunity to look at the facts, the revision facts, and see if everything that was said was true. And based on past records, it hasn't been true. The public has been misled. This board has been misled. And to this day, we don't know how many secondary buildings are going to be built. I don't get it. This meeting needs to be postponed. It needs to be legally advertised so the public has another opportunity, and all the documents in the revision should be scrutinized by the public and other experts.
no clapping, record.
I heard hurts your case when you clap.
My name is Shannon Larson, and I agree totally with the person that spoke before me that this really is not fair to the public. It's not fair to you, and it's certainly not fair to the Aboriginal and Indigenous peoples. I'll just talk about the estuary, because I was told that that is where, in some of the correspondence I have here, that the two Aboriginal Indigenous sites are located. Is this true or it isn't true? I don't know. Secondly, I have correspondence in here saying that they will be adversely impacted, both sites. If it's true that they are in the estuary area, that's probably why they would have been adversely impacted. If it's not true, and there's someplace else on the property, then are they still going to be adversely impacted? I have other information from DHR, the Division of Historic Resources, in communication with the Southwest Florida Water Management District, stating that they're not going to be impacted. And I have correspondence from Jason Aldridge saying that he is okay with the plan that was submitted as long as it doesn't impact the sites. There may be minimal, but they cannot put the machinery up on the sites. But where are the sites? You don't know. I don't.
We're going a little bit outside of the
I'm
two areas.
I'm tying this into the lagoon. So if they are in the lagoon area, then we don't have anything to worry about because they're not going to be impacted. They're not going to be dredged. But what if you hadn't made that decision? What if they hadn't made that decision and they are in the lagoon area? They would have been destroyed. They would have been dredged up. Is that right or is that wrong? It's right. So I am very, very, very disappointed in the staff and the board and the team put together by the developer. So much false information is being put out. In their Exhibit 20, they submitted to you a draft report of Janus Research that only included one site. That's very deceptive, very, very deceptive. That's all I have to say. I think this is criminal to me. Thank you.
Thank you. Please come forward and please try to keep your comments to the issues that changed today. That's what we're open the public hearing for.
And I have been sworn, and this is related to what was changed today. I would like to know who's going to tell the Planning Commission that they recommended something that doesn't exist. I ran into a commissioner today, and I said, new GDP, and he said, has to come back to us. Why you're not doing it? You did it with the two buildings. This is a new GDP. Yes, I left that note for Sarah, and it was taken from her desk. Yes, that's me. You can put my name right on it.
Okay.
We do things, we do them right. We don't do them wrong. You did it for the two buildings. This is a new GDP. So anyway, who's going to tell the Planning Commission? Thank you.
Thank you. Please come forward, state your name for the record, and whether or not you've been sworn.
Larry Grossman, and I have been sworn. I'm speaking somewhat reluctantly because I speak under protest because I don't believe that this procedure is legal or equitable. There was no notification that you were going to reopen the public hearing. And so all the people who have left, who never showed up because I didn't think they could speak in the first place, those are the missing folks who were not equitably treated. And yet, since I think you're going to pass this, I need to make my comments, or else they'll get lost. There's an issue here on A18 when it uses the expression "further approval," and the attorney Shank commented on this that there is no further approval. When you approve, and further approval has no meaning to me, legal meaning, because what discretion do you think you have in further approving something you've already approved? So I hope you can look at that. I hope you can look at the fact that you have another contradiction, that you're going to approve 16 buildings of 95 feet, and yet the applicant's going to come in and show you that this is not going to have a wall effect. We don't know what a wall effect is. It's pretty much undefined. It's like pornography, you know. Well, that's pornography, but that isn't? I don't know. There's no definition of what a wall effect is, and you're going to be asked at a preliminary planning, site plan level, to make that determination when, in fact, you may only be getting a portion of the site, that phase of the site. So how are you going to look at the total accumulated effect of all of these buildings, the number of which we have no idea? I just raised that issue, and again, I don't think this procedure is proper. Ms. Shank has not said whether this is a minor change or major change. I think it's a major change. Thank you.
Thank you. Please come forward, state your name for the record, whether or not you're sworn.
Hi, I'm Sandy Rittberger, and I have been sworn. I want to agree with the fact that we are at an impossible disadvantage because we have not seen these changes. The public has not seen these changes. I'm very pleased that the lagoon has been removed. However, the wetlands that had the Brazilian peppers were part of the area, as I understand it, that were going to be dredged and removed. So what happens now for these wetlands? There's no way for us to know. They shouldn't be removed, but are they going to be removed? So I think there needs to be a wetland impact study along with these changes, because removing the lagoon definitely does change a lot of other things, and primarily the wetlands that are there. So please postpone this and allow us to take a look at what's going to happen to the wetlands and in several other areas. Thank you.
Barbara Hines, Minnesota 88, Holmes Beach, and I do have my letter, and hopefully I won't be speaking that long.
Only on these things.
I'm not sure the letter. Can you submit that for the record, please?
I will, definitely, and I apologize, my printer went wonky. Glenn sent it to me over the computer.
Please go forward.
Go ahead. On the items that were.
I hope the timer isn't on. It is?
Not yet.
Oh, my goodness. Okay.
That's what I thought. I knew. Okay. All right, go ahead.
Even after my cataract surgery, and my doctor says that my vision is 20/20, I could not read I could not read that list on any of your monitors. And I suspect that people are right, that nobody could read on the monitors. But again, it takes time to see something and percolate. It takes time to have questions come into your mind. I don't know, even if they're getting rid of what I call the dredge area, but are we still going to have a deep water canal or dredge or something?
No.
I don't know that. That's what I'm saying is we don't know. And a lot of people who have a lot more expertise than I do, they left because they were informed that they weren't able to testify. And God bless poor Katie Piarello, the ex-mayor of Bradenton Beach, how she was treated, and when she obviously made a big point to be here. And she would have been here if she had known she would have stayed be able to testify. Now, we're here today because the applicant wanted more time. We're here especially today because the applicant wanted to make sure that the commissioner who was on vacation or whatever, on somewhere, was here. But yet, now we're going to rush something that you just got in your hands, something that we don't know what this wall-like thing is, or we don't know what type of terracing they're talking about. We don't know what they're talking about. And you can't comment intelligently when you don't know what the facts are. Do I like the concept of removing what, I can't even say what they call it, because it really is not, it's not a lagoon, it's not a whatever. Yeah. Do I like the concept of taking out the wall? Absolutely. But do I know what this actually is going to do or not do? No, I have no clue, and I don't think most people do. And I would, again, ask that your decision happen after we have a chance, you have a chance to think about it, and we have a chance to research it. And it's possible even the planning commission might have to look at it. I don't know. I don't know if this is major or not. It sounds awfully major to me, but that's just my opinion. Thank you.
Thank you. Please come forward and state your name, whether or not you've been sworn.
Ed Goff, and I have been sworn. I agree with everything that's been said. In my mind, I really can't visualize exactly what's happening. I think we're kind of back, we've taken a step backwards from that very first meeting where everybody's saying, what's going on? I don't understand it. And then you kind of had to cancel it. Well, we got a sort of a mini situation now, and we don't have documentation. The staff has not made a report on it. We don't have anything in writing for the record. We don't have anything. There's a lot of people that wanted to speak that aren't here. And as I looked at the map, I kept on thinking, what about that huge lake that we know is already dredged? And I actually contacted Swiftmud about that, and they said they didn't have any idea about that. They didn't know anything about it. They didn't have a permit, as far as they knew.
Please stick to the items that are up for discussion
Well,
today.
it appeared to me that the canal or the enhancement area was going through that area where you could see from the overhead photos had been dredged out. So that would be part of the waterway that was proposed. And you've seen those photos, I'm sure. And I'm thinking, how is that going to fit into it? Because it wasn't it's not on any of these maps that we see. How come that's not there, but the canal is gone? And also, there seems to be two different things. There seems to be a lagoon, and there seems to be an estuary enhancement area. And I don't think they're the same thing. People are talking like they're the same thing, and I don't think they are. I think the lagoon is that lake that I'm not supposed to talk about. And it's going to have a beach and all that stuff. And we don't know. There's just too much that we don't know. I really don't think that it would be fair to the public to make a decision on this today. Thank you.
Thank you. I just want to make it clear, the reason we're not talking about things like the lagoon, because they were part of the public hearing last time. We're trying to focus on the items that are new in this public hearing today. Thank you.
Madam Chairman, can you indulge me in reading stipulation A18, because nobody's read it into the record, and we heard Mr. Vogler's summary of it, but my comments would go to A18, but I have no idea what it says, other than a perception, and I'd rather, if you don't mind, read it for.
Do you want me to read it?
Yeah.
Oh, sure.
I don't have it.
Sure.
You'll use this
Can
time.
do
would
you
help.
have any extra copies of what was handed out
I asked,
that you could give
they didn't have anything over
Mr.
there, but
Flash a copy?
Can you read it?
I'm going to read it.
Thank you.
Subsequent residential dwelling units, upon completion of the first 750 residential dwelling units, shall require further approval by the Board of County Commissioners at a public hearing prior to or as part of preliminary site plan approval in increments of 750 units or more. Any approval shall be in conformance with stipulation A16.
Okay.
And the intent of this was to take out the words phasing,
Correct.
because that was the issue.
I just wanted to make sure it was specific, because when Mr. Vogler read it, he left out, I believe, the word preliminary site plan approval, and you said it.
Yeah.
And so as long as it's in there, then that'll save my comments about that. This is what we are talking about? If you could zoom out a little bit. All right. I'll start with the top left. Let's see it. Well, you're not going to be able to see it perfect, but, you know, it's what
Zoom in
you're
a little.
shown. The
Go
top left is,
What you did.
still has wetland impacts here, here, and there. And there's no wetland impact study that really matches this general development plan, and it was all based on previous stuff, so I'm a little concerned about that. Also, as I stated this morning, underneath general comments, but it also applies now, as it did before, your land development code requires you to actually show, at the time of approval, these existing habitats, hammocks, pine prairies, scrubs. I know that staff has identified these in previous meetings as upland mesic hammocks or some type of hammocks there. I know over here is an active eagle's nest, and I've asked several times to the planning department to make sure this was shown on the general development plan, which is supposed to. You showed this
There's no
one.
change, we're not going to discuss it today.
Well, you're changing the plan, but I'm just saying, the plan does not include what's required, the new plan. It needs to be consistent with what's required, that's all I'm asking. I think from the standpoint of legally protecting the county from any type of action, if it's shown on the plan as it's required, then there'll be less of a chance for the county to challenge. So outside of that, I want to just thank the applicant for making the changes that they did. Okay, Mr. Broof. I think that we've come a long way with the environmental concerns that we had in this community. I'm still concerned about what you're actually approving as far as building-wise, Commissioner Whitmore and the rest of you, is because I'm not sure if you're approving all the buildings that are still over 35 feet without having those findings, those 7 findings. As you know, when we did this in 2004, there was 7 specific criteria they need to show you to make those findings. If it's coming back in a preliminary site plan in the future after those 750s, then that's great. And just for the record, in 2004, we approved 272 dwelling units on 102 acres. So if you multiply that times 5, it might have been around 1,200 or 1,500. And we did have the intention of carrying out that plan throughout the whole area. And actually, as you know, you settled with Mr. Broof when he sued you. You settled on the actual cost of the Elcon because we were committing to a level of service for the entire phase, all the phases.
Thank you.
You eliminated that.
Please come forward, state your name for the record and whether or not you've been sworn.
Hi, Jack Merriam, and I have been sworn. I just had a point of information or a question about the exchange between Commissioner DiSabantino and Tom Gerstenberger. And as I understood it, Commissioner, you were asking about the elevation of El Conquistador Boulevard. And and I don't have surveys on it, but I did look at, and I was using Google Earth, and you can get the elevations of various points, and it seems to me that what I heard from Tom was that the elevation was 12 feet, and as you got down towards Legends Bay, it was about 9 feet, as what I saw on Google Earth, and then it went up, I think, as you went back to the west towards Tidy Island. And I'm not sure what your point was there. I was concerned, and I looked at it because of wondering what was going to happen when they filled the property. And if the road was lower than the property, was it going to divert more water onto the road? So just a point of information. And again, I don't have survey. I'm not sure I'm correct about the elevation, but I believe that's what I saw on Google Earth.
Thank you.
Thank you.
Please come forward, state your name for the record, whether or not you've been sworn.
My name is Stuart Smith.
And you've been sworn.
And I have been sworn, yes. I would ask first that you follow your attorney's earlier advice, and despite the fact that everything has been resolved between stipulations and GDP, that you not do it this way with stipulations, but rather take a new GDP, properly reviewed by staff instead of in 1 hour, and notice to public comment to accommodate these substantial changes and provide proper due process. Eliminating the lagoon and the wall is a welcome solution. But as your consultant, Mr. Pride, said earlier, this leaves you with the problem of mitigating wetland impacts elsewhere. And that wasn't part, I think, of what was presented to you in this revised GDP. And there are other questions, too. For example, with this plan, welcome as it is, you have a 50-foot buffer. Previously, we had a lagoon that was average 120 feet, then another 50-foot buffer before the buildings started. Those buildings were purported to be on some of the forms that Ms. Servia showed you, 210 feet from the shoreline. Does this change in the distance change how far back those buildings are going to be from the shoreline? These are other unanswered questions that are that make this a bit incomplete. And finally, I want to remind you that the applicant still has, as been said before, he's still not complied with 402.7.d.9, requiring that elevations of plan views of all the buildings over 35 feet be shown at these public hearings, and also show you their relationship on the property. He's not done that yet, and you really should not approve a special finding until he does.
Anyone else, please come forward, state your name for the record, and whether or not you've been sworn.
Mary Lynn Parker, and I've been sworn. I also, as well as many of the others, protest this procedure for not noticing hearing is open for public comment. I also take exception to the comparison of these changes to possibly changing an entryway into another development. I'd like to have clarified what the material in the buffer will be. I'd like to have clarified or verified that the peppers will be removed as they should be by code, and that the 1 to 4 grade begins after the buffer, and that the buffer not be used as that 1 to 4 grade. Thank you.
Anyone else who'd like to address the board on the changes that have been proposed today, please come forward and state your name for the record and whether or not you've been sworn. Okay, seeing no one else come forward, I'm going to close the public comment portion of this hearing. I want to ask Sarah, before we move forward with the deliberation, and we are going to give the applicant a chance to rebut anything he's heard today, but my recollection is that this public hearing was continued, and we even stated that we would have to determine whether or not to have public comment once we saw what was submitted. That's my recollection.
It's my understanding that we closed public comment, but we had a conversation, because at the point we didn't know exactly what the applicant's going to submit.
Right.
That if it was a substantial modification,
Then we'd have
it was
to-
at the applicant's risk and we would have to reopen public comment.
Okay, so
And
the reason I bring that up is everyone says, well, we didn't say we would take public comment. I'm pretty sure even before we broke for lunch, I said we'd have to determine whether or not we're going to take public comment. So I don't think that's an accurate statement. I think I've said all along, depending on the changes we got, I said it last time, if you look at the board action, it was a continuation of a public hearing, and that was made, and we said we would determine, based on the changes, we knew we were going to get some changes, because that's why we continued it, whether or not we were going to take public comment, and we did. So I would say that that's an inaccurate statement to say that people didn't know they were going to get an opportunity. It was up in the air. We did not know, depending on the site plan that we got back.
And Madam Chair, I do want to add that we determined that with staff that since the changes made the project less intense, because we're removing characteristics of use such as the extra enhancement area in the wall, that it was not legally required to go back to Plan Commission.
Thank you. All right, I'm going to give the applicant an opportunity to rebut. The standard rebuttal time is, I can't remember.
5 minutes.
5 minutes. So you'll have 5 minutes for rebuttal.
Thank you. My name is Ed Vogler. From the beginning, I have been sworn this project has sought to be a catalyst and extraordinary environmental steward. In the original presentation made to you, you'll recall that we sought no special consideration, and we enjoyed staff support and recommendation of approval. We have listened to the public and to the commissioners, and we have made further revisions that largely are welcomed, I think, by several commissioners and by some of the members of the public. But the important elements of this decision are that what's presented to you today is consistent with the comprehensive plan and the land development code. You have your staff recommendation for approval. That staff recommendation for approval existed prior to these new stipulations. These new stipulations have been designed to request the support of the board and to make transparent commitments to you individually. And we have done that, and we would appreciate very much your favorable vote today. Thank you.
Thank you. And I think some commissioners might have comments, so you probably, or questions, because
Okay.
of some of the questions we heard we would want answered. So I want to just hang out. Commissioner Whitmore?
Well, the citizens that have sent us emails and that I've been listening to for a year or so, and plus, remember, I was at the last meeting that lasted till 1 a.m. or 2 a.m. And but with this news plan, the 145-foot building was the biggest one that I had heard, and also the estuary, and they're gone now. So my concern was the environment along the bay, saving the kitchen, and living on the island for 48 years, maybe a lot of you don't, I've lived there for 48 years, was the height of the buildings. The height you compromised on, the 95 feet, or that you brought before us, is compatible with the project next to us. So, as Joe McClash said, you know, I agree with Joe. My biggest concern was the estuary, and mine was the height too. So I'm comfortable with what we've done. You have a right, a future land use of 2,894 units, and that's what you're asking for, no more.
Yes.
And so I'm comfortable, something's gonna get built there. I'd rather not fight over this and get sued and then lose it, like we've done on other projects, and then you can do whatever you want, and that's not what I want. I do not want that estuary, so thank you. And I'm okay with what you presented to us. Thank you, Madam Attorney, for clarifying about the Planning Commission. That's kind of why I read why the three voted against it, because those issues are all gone now. And I just felt I needed to also enter that. Thank you.
Thank you. Next, one of the questions we had, which is the start of the grade, is that starting from the wetland buffer? Is the wetland buffer to remain undisturbed?
Well, the wetland buffers are treated like every buffer under the Land Development Code, and it's hard for me to pick and choose what comments to respond to, because
I'm going to ask you specific questions,
Yeah.
so that's.
So of course, there's a very extensive Land Development Code standard for engineering of all of those things. No engineering has been done, you know, detailed engineering on this site yet, so they'll.
Okay, well, maybe I could ask the question in a different way. You're going to observe the wetland buffer, which per our staff does not allow any filling in it. Is that correct?
That's my understanding, unless you have a permit to the contrary.
Okay, so I think the correct answer is, and staff, I was trying to get it out of the applicant, but staff, maybe you can concur. Wetland buffers do not allow filling, is that correct? I know what the code says, so I'm just trying to get staff.
On record.
Wetland buffers are to remain in a native condition except for removal of exotic species and planting of native species.
Peppers.
Thank you. So you cannot start your 1 to 4 grade in the wetland buffer, is that correct?
Technically, that is correct.
Okay, the technicality, we're saying we're going to meet the code, so that's the answer, that you cannot. The question was simply asked, does the 1 to 4 grades start at the edge of the wetlands, or does it start at the edge of the wetland buffer? And it appears to me it's at the edge of the wetland buffer. I guess I'm done. The other question that came up about the major stormwater change, because of the fact that you have these existing ditches that come out. Maybe if you could comment on that, because there was a question about taking out the estuary enhancement area as a major stormwater change. I wonder if you could comment on that.
Drainage.
Well, first, I need to say, and this is part of our record, that we have an agreement with our neighbor, Manatee Fruit Company, that we've placed into the record. And they have rights of conveyance or discharge from their project through those same ditches and into the bay. And I'm quite confident, having watched all of the Lake Flores matters, that these questions were not presented to them. But the answer is, we advocated for the estuary enhancement area as a means to manage some of the turbidity. And so we will need to have other means to manage the turbidity. I mean, we advocated for the wall for various reasons, but it's not like your codes don't allow us to engineer a proper solution for whatever these concerns are. And they will be engineered and solved.
Thank you, that's what I thought. Question about the 210 foot from shoreline. That was in, that was a submittal of, at some point, I don't know if that changes.
Well, that's just a wrong statement that was made to you. It's 210 feet from the mean high water line, and we've presented evidence over and over again that the closest is 660 feet from the mean high water line, so the 210 is like nothing.
Okay. I thought so, but I wanted, because that was a question, I want to make sure that it was clear. Commissioner DiSabatino?
Wanted to thank you for removing the estuary enhancement area, AKA lagoon. That's a big load off all our minds, I think. I'm still struggling with the height of the buildings and not knowing, I know 16, but I don't know the number of the other ones. Why are we or are we not entitled to know how many buildings there are?
Who are you asking that question to?
I guess the applicant or staff, why aren't we entitled to know how many buildings, how many single-family homes, townhomes, twins, villas?
Commissioner DiSabatino, I want to answer this question to you in the most direct and kindest way that I can. This is a general development plan, and this is the methodology by which large projects are approved, including DRI projects. The essence of what I'm hearing you say is that you're only going to be comfortable if somebody presents you a preliminary plan or even a final site plan. And over a 20-year project, in the first year of the project, that doesn't occur. That's not the real world, and that's why your codes are set up the way they are. And so I don't think one could ever satisfy the criteria that you're mentioning. And I want to go just a bit further. When I came here in I came earlier, but when I started practicing law in the early 1980s, there were no large projects, okay? There were small projects, 40-acre tracts that were built into subdivisions. Just look at Northwest Bradenton, right? I worked on Circle and Bar Ranch, DRI, University Park, what we now know as University Place. And what happened with the 1989 comprehensive plan, we created a community that valued master planned communities. One of those we might know as Lakewood Ranch. And I promise you, If you look at the original approvals of Lakewood Ranch, the level of detail that you're requesting is non-existent. Yet would you say today that it is somehow misplanned? So what we've done, primarily to accommodate the concerns that you have, and to ask you for your positive vote, and hopefully a unanimous vote on this matter, is to say that we're going to bring it back. We're going to bring it back to preliminary site plan standards. You even heard Mr. McClash say, boy, that's good. So I don't know that we can satisfy you, but I think you should be satisfied.
And I want to just clarify, the proposed uses have not changed. 2,894 residential uses to include 2,384 multifamily units and 510 lots for single-family attached, single-family detached, single-family semi-detached residents. Is that correct, staff, that those specific lots and multifamily and single-family have not changed?
Correct. The breakdown of the different types of units or the grand total of units has not changed.
Okay, thank you. Commissioner Sabatino? Commissioner Trace?
Just to answer the question, hasn't, someone asked about the invasive weeds, the Brazilian pepper. Those are you going to be able to clean them out without dredging, or what's your plan there, since most of them were in the enhancement area?
Well, you're mandated to clean them out. They're not dredged. They're mechanical applications for doing that, but it's mandatory.
So they will be gone.
They will be gone.
Thank you.
Good.
All right, well, that's the last commissioner I have on the board. Closed public comment, we've had rebuttal. Anything else?
I have one more question.
Commissioner?
Sorry, Mr. Vogler, sorry. Could you address the issue about the mounds?
Yes. I didn't follow the comments because she suggested that the midden mounds were within the estuary enhancement area and would be dredged. So one would think that you would be very satisfied about that. The second point is there have always been 2 mounds identified, period. I don't have the numbers right in front of me, but there are 2. And number 3, as your council has indicated, there's a state program and procedure that vests jurisdiction in a state agency, and there's a very specific stipulation that deals with this and hasn't changed from the beginning.
Okay, thank you.
Okay, well, that completes our deliberation. What's the pleasure of the board?
Go home.
Robin, don't do that.
Okay, well, I'll make the motion that we approve PDR/PDMU-15-10 as recommended by the staff.
Second. Can I have a clarification? Is this based on the new recommended motion with the new stipulations that were handed out today?
Yes, it is, as I'm reading from the sheet that was handed out.
A18 through A22, to be
Correct.
specific.
Okay. So is that clear to everyone what the motion is? What we're talking about here? Okay, I have a motion and a second.
Question.
Commissioner Smith.
Thank you, Madam Chair. You know, I've sat here and listened to the testimony of the public, and in this meeting and other meetings also, I will listen to the testimony of the public. The applicant has done everything that I've asked. The recommendation, stipulation that we talked about, it was from public testimony that came before us with concerns from the residents, and we moved forward and we adjusted those concerns based on what took place. As a constitutional elected county commissioner, I cannot make decisions based on the fact who Carlos Baru is or who people think he may be. I have to deal with the evidence that come before me. I am satisfied with what has taken place with the application. It's still the due process. And I understand how some of you may feel. I've been in meetings where I've been on the other side of a vote and lost, but I can assure you that you've received a whole lot more due process than a lot of other people dealing with development in general. This been going on for years. And certainly, the idea that in this meeting, that this board, this commission, cannot adjust to the wishes of the testimony that some of you came to the dais and stated to us, to me, makes no logical sense. I realize some of you are not going to be satisfied with this vote, or the fact that you may not ever want anything done there, and I get that too. I understand that. But at the end of the day, I have to deal with what I've heard in this room. And the applicant has conceded everything that this commissioner had concerns with. I have no right to oppose this project based on who the applicant is. Thank you, Madam Chair.
Commissioner DiSabatino.
Yes, very well said. I feel the same way. I know coming into this, I didn't approve that estuary enhancement, and I was very pleased to see that it's been removed. As you all know, I'm not happy with the height of the buildings, but this will pass. And, you know, it is not realistic to think that there's nothing going to be built there. A lot of people don't want anything built there, and I understand that. So I never thought that we'd be talking that the enhancement area was removed, because I think that was most of the people's biggest concern. They don't want the tall buildings there. But I'm sure that his intent is to make it look like a showplace, and hopefully, as Commissioner Smith just said, no one, a lot of people are going to be upset one way or another. So I'm just satisfied that we removed the estuary enhancement. The buildings aren't 145 feet tall, like Commissioner Whitmore said, and can't win them all, so we just have to move on, and that's it. Thank you.
And just before we vote, I just want to say that I think the public has weighed in. The public has done a good job. You've done your homework. You've brought experts. You've brought concerns to this board. Hasn't always been easy to get through the process, but you certainly worked very, very hard, and significant changes were made throughout the process because of the public weighing in. So, and it may seem like we don't appreciate it, but we do. It's part of the process. So I think we've made a lot of progress. I'm pleased. I stated right from the beginning what my concern was, so I'm pleased that we have our comprehensive plan being upheld in this approval, and that's the way that I view it. So I know not all of you will view it the same way, but that is the way I see it at this point, so I'm going to vote in favor of the motion. All those in favor of the motion, please raise your hands. All those opposed? Okay.
Done.
It's passed.
Hallelujah.
And again, thank you, everyone, for your patience in being here. And that is the last item we have on this agenda. We've already had commissioner comments. If there's nothing else to add, we are adjourned.